what happened in Uttar Pradesh with the mosque survey and the violence that happened later. There are legal stalwarts who have said that this is because of what happened with the Ayodhya judgment. There's a bearing that happens, like it may not, but then judges will get affected, won't they?
Obviously, judges across the spectrum have to understand that they are here to decide in terms of the law. And if there is a particular law which they have to apply, then they have to apply that law. And if there is an error on the part of a judge that's capable of correction by a higher court.
When you said, I pray to a deity for a solution to the Ayodhya dispute. Now, this was termed shocking, and that you asked for divine intervention.
I derive a great deal of comfort and solace from being a person who practices my faith. Your ability to do justice in court and in terms of the constitution, the law, does not depend on whether you are an atheist.
So he says the reality of India is that the opposition taken upon themselves to do the task of the media and the judiciary also.
People should not presume that the judiciary should be performing the role of the opposition in parliament or the state legislatures.
Is there political pressure on the Supreme Court?
No.
ये right wing judge है, ये left wing judge है. This is how people talk.
कहने वाले कहते रहेंगे.
Namaste, Jai Hind. You're watching or listening to another edition of the ANI podcast with Smita Prakash. My guest today is the former Chief Justice of India, Dhananjaya Chandrachud. This is the longest podcast or interview that the Honourable Chief Justice has ever done, 2.5 hours. Justice Chandrachud served as the 50th Chief Justice of India from November 2022 to November 2024. He's also served as the Chief Justice of the Allahabad High Court and the Bombay High Court. He's been part of benches that delivered landmark judgments such as the Ram Janmabhoomi verdict, Article 370 special status of Jammu and Kashmir, decriminalization of homosexuality, same-sex marriage and the Shiv Sena status. His tenure as Chief Justice of India also saw intense social media scrutiny over judgments, and there have been a spate of articles lately about the legacy he leaves behind. All this and more in the conversation. So, thank you so much firstly for coming to the podcast. How do I address you? That's a major thing. I've researched and everything. Do I say your lordship, your honor? How do I address a retired Supreme Court judge? I don't know.
I was uncomfortable about, lordship even when I was in office. So obviously that's completely out. And I think by my first name is fine.
No,
everybody
my
calls
goodness,
me Dhananjaya.
that's going to be impossible. But anyway, I just want to know, before we get into your judgments and all the controversies and all, I just want to know about how does it feel with retirement and what are your retirement plans?
Well, actually, retirement isn't easy because I've been doing nothing else apart from working as a judge for 24 years. And suddenly you realize one morning that there are no files to be read for the next day. And then you get up in the next morning and realize that there's going to be no going to court and sitting there, which has been part of life for all these years. But then after the first couple of days, you sort of breathe the air of freedom in the sense that, any judicial office comes with so much of restraint, responsibilities, the routine, the isolation from society because of, the kind of post which you occupy, whether as a judge of the High Court or Chief Justice of a High Court or judge of the Supreme Court. So in that sense, I've been enjoying just the ability to meet people, go out on my own, visit bookstores, and of course a little more time to listen to music and do all the things which I have really missed out in the last 24 years.
Isolation, if I may ask? Aren't judges very social people?
No, judges actually, it's to the contrary. At a certain level, you see them social in the sense that they'll attend legal aid clinics or they'll go to law schools to talk to students. But deep down, you're really very, very isolated because you don't make new friends as a judge. That's at least the policy which I followed. So the only friends which you have are old friends and friends which you make on the bench, colleagues you come close to. But then as a Chief Justice, there's another restraining factor which is that you have to be equal in all your colleagues. So you cannot have favorites among colleagues as well. So, all in all, life as a judge is really very different from being outside. You have to be connected to society in the sense you have to understand what's happening on the ground. Otherwise, you can't decide cases. But at a personal level, the number of people you associate with, the kind of people you associate with, is you have to take so much of care because there possibly could be a connect with the case you are deciding. Someone may have an interest. I'm not saying that you start with the presumption that people want to make friends with you only because you're a judge, but this is something instinctive which comes to every judge.
So now, what would you like to do? Like, I know music and interaction, all that, yes, but would you like to go back to the teaching profession? Because I've met some of people who've attended lectures of yours, and they say you're mesmerizing as a teacher. And of course, Harvard would love to have you back, I'm sure.
Well, actually, I haven't honestly decided because I just thought that the last few months before I demitted office was so hectic because there were judgments to complete. There were various other lectures to deliver, projects to be completed in the Supreme Court and elsewhere. I was working extensively for the E-Committee of the Supreme Court. So all in all, it was a very hectic time for me. On sane advice, both at home and among close friends, I'm just taking some time off. I think at least for a couple of weeks or maybe a month or so, which is not to say that I'm not doing some work. There's a little bit of work which is coming my way as well, professional work, which is wonderful because that gets me an opportunity to interact with youngsters, particularly young professionals, both in the law and beyond. Something which I've missed doing all these 24 years. But I don't want to be just a former judge who's an arbitrator or doing consultancy work. I have other interests as well, and I want to teach. I would, of course, like to be connected to the younger people in our society because I think that's where India is moving. The future and the present, for that matter, is of the young. There's a demographic shift in our society, and I'm enormously inspired when I talk to young people, whether they're my own judicial law clerks, youngsters who come and meet me. So that's something which I'm really looking forward to doing, which is to mentor the young. In whichever way I can. I don't want to sound pompous by saying that I'm capable of mentoring young people, but I'd like to spend as much of my time as possible teaching young people.
So you and I live in the same city where we are breathing this poisonous air, and most people that you will speak to, they just have lost hope that anything will be done by our lawmakers, and they just feel that it's now final Court of Appeal, it's up to the Supreme Court to do something about the matter. They pin their hopes only on the court. What do you have to say on this matter?
Well, it's great that people have this kind of faith in the court system. But I think when we deal with issues such as pollution in Delhi, the fact that, everybody's talking about it for a change in the last several years is part of the answer to the problem. Because the real problem arises when people just accept whatever happens in society as a new normal and they don't speak about it, they don't write about it, they don't talk about it. The very fact that everyone is engaged on this issue itself is the first step in finding a solution to this problem.
But it's a very pressing issue, right?
It is, of course.
So, writing about it, reporting is something that everybody has been doing for a long time. It somehow doesn't move people enough.
Now, the point is that there are two different aspects of the matter. First, you have the role of policymakers, namely the government, the expert agencies of the government. And then you have the role of the courts. None can, in that sense, be complete without the other. When courts step into this area, obviously courts cannot take over the core policy-making role, which is for expert agencies to handle. What courts can ensure is to ensure that the processes are being undertaken. Are you applying your mind to this? For instance, we had the graded action plan. Now, that was introduced as a result of the intervention of the court, in the sense that then we lay down processes and systems that if pollution crosses a certain level, these are the steps which you have to take.
Yeah, the GRAP 1, GRAP 2
that's
and all
right.
those. Yeah.
So you institutionalize processes and the response to pollution does not become ad hoc.
But do you think it's time to have more judicial intervention? Otherwise, somehow the legislature and the executive seems to be doing... they don't understand the urgency of the matter, probably. I don't understand.
Well, I would love to say yes, because I've been a judge all my life, as especially after I ceased to be a lawyer for the last 24 years. But having been a judge, I also understand the limits of a
Yes,
judicial review,
I get that.
and it's very important for judges to understand the limits of their function. Because what happens very often is that when you step into a problem, particularly a problem as complex as this, which is not a problem relating to one source of pollution, like say one thermal power plant or one polluting industry, those are typically areas which courts can work on very well.
Right.
But you are dealing with a problem which has multi-dimensional issues involved. You have farm fires, you have the number of vehicles in the city, you have new construction, you have changes in cropping patterns, climate change in general as well. So these are issues in that sense which are extraordinarily complex. So courts have to step into the area, move the authorities along, and tell them, hey, what are you doing? What are the steps that you are taking to deal with today's problems? What are you envisioning for the next year? What steps do you want to take? So very often the role of judicial review is to push things along as opposed to merely taking decisions on your own. Another problem I think which we need to understand is that when courts take decisions, we are essentially not accountable to the people in a direct sense. Obviously, we are accountable to the Constitution as judges. And pardon me for saying we, I'm no longer a judge, but just, old habits die hard. But so courts are not in that sense either accountable to the electorate or to the people at large. We, as judges, they perform roles of, enforcing constitutional rights. Now, a lot of good work in the environmental area in India has been done by the judiciary. I'll just take you away a little bit from the immediate issue of pollution. So, doctrines such as the polluter pays principle, or the principle of sustainable development, the precautionary principle, the principle of intergenerational equity, which means that we hold the environment in trust for future generations. The right to be protected against climate change, which I spoke of in one of my recent judgments on solar power. These are all the result of judicial evolution. And the Supreme Court of India has been at the forefront of global Supreme Courts in leading the march of environmental law. So, at a conceptual level, courts have a wonderful and a significant role to play. When it comes to dealing with individual problems, I have some element of caution which I must express. Because otherwise what happens is when courts enter into the area, there's a great expectation of people that, well, now the court has entered this area, you have this great power of contempt, and that everything will be normal and everything will be fine. It's not going to happen that way because these problems are extraordinarily complex. You're dealing with intractable problems. You're dealing with the issues of farmers, right? The farm fires, for instance. Now, are courts capable of dealing with the complexity of these modern problems? Which is not to say that courts should not enter into the area. We have to enter into the area.
Whether it is Yamuna pollution, whether it is the air pollution, every time people of this city complain to the local government, they say, ye LG ka kaam hai. You complain to the LG and he says that the state government doesn't do it. And then there is the central. This overlapping of Delhi. We are orphans, Delhiites. Who does one go to? What is the solution to this issue of Delhi?
Delhi is the national capital territory. Now, when Delhi was given statehood, it was given statehood with a difference. In all other states, the legislative jurisdiction is distributed in 3 lists of the Constitution. So, any other state in India, there are 3 lists of the Constitution. The Union list, on which Parliament can exclusively legislate. The state list, in which the state legislatures can legislate. And the concurrent list, in which both can legislate, but Parliament has the overriding prerogative to even override a law which is enacted by the state legislature, unless it has been reserved, unless the state law has been reserved for the assent of the President. So if the President assents to a state law, then it can prevail to that extent even over a parliamentary legislation. So far as Delhi is concerned, though it is a state with a legislature, the constitutional position is a little different. In the sense that Parliament has the power to legislate on all the three lists in relation to Delhi. So Parliament can legislate on the parliamentary list, the union list. It can legislate on the concurrent list. It can also legislate on the state list. Second, certain specific subjects in the state list are carved out of the jurisdiction of the legislature of the National Capital Territory. So in that sense, Delhi is what we in law we call sui generis, which is unique. It is a state, but it is not a full state in that
Why
sense.
didn't you resolve this issue when you were the Supreme Court Chief
Well,
Justice?
we resolved. Well, there are two judgments of NCT. The first, of which I was a part, where Chief Justice Deepak Mishra was the Chief Justice. That was NCT 1. The second, where I was the Chief Justice of India, which was the second. And now there is a third, which is pending before the Supreme Court, which of course will have to be dealt with by.
How does
Constitutional
Washington,
bench.
D.C. resolve it? Isn't that also a similar kind of a situation?
Our distribution of legislative powers is very different.
They also
because-
have Maryland, Virginia state, and then they have
right.
that.
So it's like it's very loosely. It is similar to a national capital territory, but the national capital territory which we have in the form of Delhi is governed by a very different constitutional distribution of powers. And the reason for it is while Delhi was conferred with statehood, certain subjects which would have a bearing on, say, the national character of the NCT were reserved for the union, like police, land. These are two very critical areas which were, in that sense, reserved for the centre. By the Constitution itself, when the Constitution was amended to create the statehood for Delhi.
See, the reason when you say that we are not, it's like people have to expect more probably from our lawmakers. What happens is that now that we can see there's direct telecast, so we can see what's happening in the courts, people tend to expect it from the judiciary too. You get that?
Yeah.
So it's like it's when we started watching parliamentary proceedings,
Right.
when they became live, it was more like, oh, I know this guy. He's from my area. He's somehow the mystique of that the judiciary performing in some closed rooms, that's gone now. And then now you're looking at the lawyers and you say, he didn't represent me right. Me in the sense citizen of India. So that's happening a lot. That's changing. But anyway, let me come to that later. I will come to you. When you said that, I need to ask you about, are you concerned, worried about how the people are going to look at your tenure? Because I will quote here, you said, how will history judge my tenure? Could I have done things differently? What legacy will I leave for future generations of judges and legal professionals? So were you thinking about this all through your tenure, or was it just the last couple of weeks?
Well, just the last couple of weeks. I don't think I ever thought of how people would look at a particular case that I decided. You look at that case, you look at the body of law which governs the case, the facts of that case, and you just decide it. You decide it because, you are duty bound to decide it in a particular way. When I spoke about my legacy and, how people would look at it, it was more a moment of introspection. Because, that's something which you do as a judge all the time. When you decide a case and you go home, you ask yourselves, could I have done it differently? When I went home every day from work, and suppose there was a very hotly contested case, and I tried to control the course of the dialogue in a particular way, I'd always ask myself, could I have done it differently as a judge? So this is part of this process of judging, that you're constantly questioning yourself when you are deep down within, alone to yourself and your own thoughts. So I'm sure this is something which I'll speak about, to myself. It's a conversation which I'll have with myself throughout my life.
Did you do this when you were done with Allahabad, when you were done with Bombay as High Court judges?
I think it's also a product of age. When I was a judge of the Bombay High Court, I was much younger.
You were younger, yes.
I became a judge at the age of 40. I was asked to become a judge when I was just 38 years old. And when I went to the Allahabad High Court, I was just 53. when I got off the railway station, I took the overnight Duronto. People were looking for me. They didn't realize that I was the person who was to take office as Chief Justice that morning.
But that's a big decision, right? Like
Yes.
at such a young age to decide to be a judge. I mean,
Yes.
of course, it might have been offered, but it's still to take that decision to be a
Yeah.
judge, leave being a lawyer of repute.
Honestly, I decided right away that I'm going to accept this offer of judgeship when Chief Justice M.B. Shah, who was my Chief Justice then, judge from Gujarat, and later went to the Supreme Court, asked me to become a judge of the High Court. But interestingly, I must share this with you. I accepted judgeship at 38, and then my appointment was not coming for 2 years. And one day I walked to Chief Justice Y.K. Sabarwal with a letter written by me and my colleague, Justice Sharad Bobde, who was asked to become a judge at the same time. And we both had a conversation and we decided we'll pull out of this now. For me, it was also a very personal issue because my late former wife was suffering from cancer since 1998. And there was no light at the end of the tunnel on when my appointment was coming through. So there were a lot of personal issues which I had to take a call on, like finding a place to stay, so on and so forth. And I just thought that, this was putting a tremendous burden on my own personal life. So I walked into the office of the then Chief Justice, Justice Y.K. Sabarwal, and I said, "Sir, I've accepted this, but can you now please let me go? Because there's too much going on in my own personal life, and I'd just like to lead my own life. Not that I'm concerned about earning more money or just the allure of being a lawyer, but just this uncertainty and, the fact that my wife was suffering from cancer and I was her sole caregiver at that point of time. We had 2 small children.
Your sons?
My sons, yes. The 2 girls came into our life much later. And Chief Justice Sabharwal said, he said, "Beta, these are very important constitutional offices and you can't just change your tack like this." Then I told him what the issue was and he said, "Okay, come to me next week. I'm going to Delhi this coming week and I'll talk to the Chief Justice of India, the law minister, and say that 2 of these people want to pull out." And he said, "If I can't give you some light at the end of the tunnel in a week, then, your way is the highway." And he came back from Delhi in 2 days and said, "Well, your appointment is on the anvil. You're going to be appointed. The warrant of appointment is coming next week." And that's how both of us, Justice Bobde and I, stayed on. And as it so happens, both of us became Chief Justices of India.
Right. But didn't you ask your dad for his opinion on this matter? Like, what was his advice? He was also Chief Justice, longest serving Chief Justice.
He was, in a sense, he was happy when I accepted judgeship, but he said that the call is yours because he told me, a lot of people outside would look at, the not the glamour exactly, but, the responsibilities which are entrusted to a judge. But it's a hard grind. And only someone who's been in the system for 24 years knows what a hard grind it is.
You've seen that. You were the only child of your
I have a sister.
You have a sister, sorry.
Yes.
Huh.
And,
but you've seen that hard grind that your dad went through,
I
right?
had and I hadn't, because judgeship was very different when my father was in office. You didn't have the complexity of the law, the volume of litigation which has now come into our courts, the pressures of just the volume of caseload which every judge has to deal with. And apart from that, just the new areas of law which have come, the intense scrutiny on judges as a result of social media, all of this was not there. So interestingly, when I asked my father about whether I should withdraw, he looked at me and said, "I think you're right. You need to withdraw because it's a decision for you. You have to live your decision all your life. Nobody else lives your decisions, and especially something like this. Once you're a judge for life, in the sense, even if you retire at 62 or 65, people still think that you are a judge in the sense that they look upon you with that sense, the sense of expectation of respect." And so he was completely with me when I decided to withdraw my candidature, which also was a little reminder of the fact that, the collegium system can sometimes, have produced these results. I mean, had I pulled out, I don't know whether the system would have been good or worse.
Okay,
but
so
that's
now
a
that
point.
you've come to
Yeah.
these 2 points which I want to, on the collegium system and on the social media part. Let's go on to the social media part first, and then I will come to the collegium part. When you retired, after that you've said this, जजों को ट्रोलिंग से बहुत सावधान रहना चाहिए. ट्रोल्स कोर्ट के फैसले को बदलने की कोशिश कर रहे हैं. Now this is a new phenomenon that has happened.
Yes.
The social media impact, like I said, the direct telecast. So one immediately, even Kapil Sibal had said that in the recent Calcutta
Right.
case, the rape case, where he said that we are being demonized because he was representing the government, the West Bengal government. He says we're being demonized on social media. To what extent are judges, if they are on social media, to what extent do you feel they're influenced by these media trials which are being held?
Well, as a matter of fact, I know that speaking for myself, I'm not on social media. And I dare say all the judges of the Supreme Court, none of us is on social media. But obviously, you tend to look at YouTube and, you look at some of the websites which have to deal with the law. But there is this new normal which has emerged, which is that constantly, the social media is being used to affect the way a case would proceed in court. Now, when we took the decision to live stream court proceedings, and I stand by that decision, I think live streaming of our court proceedings, as you just said a little while back, has truly taken the work of the Supreme Court to the homes of people.
Yeah.
They realize the seriousness with which problems of the moment, problems of the day are taken. Even small cases like a motor accidents case where, someone fell off, say, a farm tractor and died, or, a small thing, seemingly small case like that, occupies so much of time of the court on whether, the parents of a deceased should be given 7 lakhs compensation or 10 lakhs compensation. We deal with these cases very seriously. So in that sense, I feel that, live streaming has truly enhanced the credibility of the work of the Supreme Court of India, because people see what seriousness goes into the decisions of not those big ticket constitutional cases only, but every little case, somebody's land which has been acquired, for a public project, somebody's partition suit, so on and so forth.
But it's also on language which is used. I mean, for example, Izzat Lootna is not the right thing to say when
Right.
it is rape. Where these sensitive things where you do say, turn around and say that, use the word.
Absolutely.
Because, and don't make it a question of honor has been, loota hai
Oh,
and things.
absolutely. But, in
Yeah.
fact, we recently, before, this work actually began during COVID, when the work of the court was not of the same intensity as normal. So we brought out this gender handbook, because I found that in a lot of discourse concerning women, the words which are used particularly to describe women who are victims of violence are extremely pejorative. For instance, a woman who is in a relationship is referred to, or was referred to, as concubine. A woman who was raped, they would say she was ravished, or they would say that,
Ravished, not ravaged.
No,
Ravished.
ravished. Then, another word which was used was that, the act of rape brought shame and dishonor to the family.
Yeah.
So, the reason why I thought we should come out with this gender handbook was to tell people why, people in the sense, decision makers, lawyers and judges particularly, and then the outside world, why are these phrases wrong? Why is rape is an offense, and rape is morally and fundamentally legally wrong, because of the fact that it involves the violation of the dignity of that human being, of that woman. It amounts to breaching her own personal autonomy.
In fact, this was quoted in Europe and in America also,
Yes.
when regarding termination of pregnancy and
Absolutely.
those kind of judgments which
Yeah.
came out from the Supreme Court were quoted also there.
So we, in the gender handbook, we have sort of given alternate phrases. We have sort of explained why these phrases are not acceptable in contemporary times. What could be an alternate phrase that you could use? And the reason why I thought this was important is that in so many ways I felt as a judge and as a human being that English is and is not our language. because it is our language, because we have our own Indian English that we speak of.
Yeah.
But at the same time, a lot of these phrases have been just handed down from generation to generation from
Yeah.
colonial times.
Yeah, so the legacy issues.
And today's
language.
judges, I must say this, that today's judges, whether in the district judiciary, the high courts, or even in the Supreme Court, they are not from this elite class of society which is torn away from the rest of society. They're all people who have come from the grassroots. And so many times, colleagues in the Supreme Court would tell me, for instance, that the first time I actually engaged with the English language was after I passed out from college or when I joined the profession. So this gives you an idea about, where the judiciary today comes from.
But sir, coming back to this whole social media thing, even the traditional media, during the course of, you being CJI, there have been a spate of articles about you. And even after completion of your term, there's this conversation. Do you just feel that this is a new phenomenon with Justice Bobade and then with you, a lot of media attention on your tenure? How do you deal with it, firstly?
See, media attention on the tenure of a judge and of a Chief Justice is to a certain extent understandable, especially if you decide important cases. And I think that's one thing which I try to do. I tried to decide as many important cases which were languishing for years, irrespective of whether, they were, in that sense, politically important or socially important. Just the fact that these were important constitutional cases which were pending for years in our Supreme Court. Cases dealing with the federal structure, for instance. The question of...
So you're okay with that? With this, that your judgments got passed to such a great extent and you were criticized personally?
Well, being okay with that is really, it begs the question, but I should have anticipated it, that these are judgments which are going to change the future of our society. Now, see the case like, who should tax mineral rights? Should the states tax them? Should the center tax them? Who should have control over industrial alcohol? States or center? What is the nature of cooperative federalism under the GST legislation? Or for that matter, private property? Merely because an individual is a part of the community, does every property of the individual become the material resource of the community? We overruled an earlier judgment of our court, which had said, yes, an individual is a part of the community. Therefore, everything that an individual owns is a material resource of the community which can be acquired. So these are really cases which are going to change the future course of our society. So having laid down, the law in these decisions, it's but natural that people are going to discuss these decisions. I have no problem about that. My concern, however, is this: when people go beyond the judgment and start, attacking the judge. And what's happened in social media really is that, particularly in a polarized polity, you have segments of, this opinion which is sort of be generated in social media. If you decide in my favor, or if you decide in favor of the opinion which I think is the correct line to take, then you are independent. If you take a decision on the other end of the spectrum, you're not independent. Now, that's not how judging goes. Judges judges are not born to be either liberal or conservative. These are phrases which are used by the political commentators.
But that's what happened with you. When you came, everybody was like, oh, here's a liberal judge. And then came the Ayodhya judgment. And that's where people said that, what has he done? And you didn't even sign that. What happened? Why didn't the judges sign that judgment? What happened?
You want me to answer the latter? The latter?
Both.
Okay, yes,
whichever
certainly.
way you want to.
Okay, I'll answer the latter part, lest I forget to cover that in my response. Ayodhya was an issue which had really, in that sense, covered a whole history of several hundred years. It was an issue which had threatened to tear apart the social fabric of the nation. And when we decided the case and we ultimately sat in conference, Chief Justice Gogoi was our Chief Justice at that time, a decision was taken consciously by all the judges together that there shall be no attribution of authorship to the judgment. And the reason for that was we all felt that it's important to send this message across that every one of us, Justice Gogoi, Justice Bobde, me, Justice Ashok Bhushan, and Justice Abdul Nazir, we stand together on this issue and we speak with one voice. And that was the intent behind not attributing authorship to any one person in the judgment. Of course, though there have been speculation outside on who actually wrote the judgment. That's besides the point. So that's the...
How much of it was yours, or can you speak about it?
Well,
No.
as I said, we haven't attributed authorship of the judgment. So as an institutional
sentences, 15
as an institutional person, I should stand behind
Okay.
that, because
I get
we decided not to attribute authorship to the judgment. Speculations are for others outside. For me, I'm part of, as a disciplined soldier, that, well, it was a judgment of the court.
But did it weigh down on all of you? And on when you were sitting down, did you realize that this goes back centuries, and what we do today is going to impact on billions of Indians? Today, tomorrow.
Well, if I were to answer that question in the negative, it wouldn't be a correct answer. Obviously, when you decide cases, you understand the significance of the issue which you are considering in this context of the wider polity. But having said that, when you actually try and analyze a case, now that was a first appeal. It was a first appeal from a suit or suits which were filed before the Allahabad High Court. Now, when you deal with a first appeal as courts, there is a very significant body of law on how a first appeal has to be dealt with. And when we dealt with the case, and I'm not speaking about the merits of the case, because that's now, our judgment is part of, it's public property. It's for others to talk about the judgment. I'm just talking to you about, the generality of the processes, which is that when you deal with a first appeal, how you deal with a first appeal is now written in stone for all of us, because we've dealt with numerous cases, either first appeals and then second appeals or revisions. So this is part of judicial process. So while you are, of course, it would be hypocritical to say that a judge is not does not bear in mind the fact that you are dealing with a seminal constitutional case. At the same time, the processes of reasoning which you apply, the yardsticks which you apply for decisions of those cases are governed by the standard and well laid down parameters for the exercise of the first appellate jurisdiction, as it was in that case. Going back to the first part of your question on, the second part was on authorship. And the first part, you spoke about, people trolling judges. I have no difficulty about people critiquing judgments of courts, because obviously today we are deciding cases of seminal importance, as in the high courts, in the Supreme Court. Even when district courts either decide to grant or not grant relief in a particular case, it might have wider ramifications. So people are entitled to comment, critique. I have no difficulty about that. My concern is when individual judges are trolled for the reason that the decision which they took in that particular case does not accord with the view of a segment of the population. And that is why, you said that, well, I was regarded initially as a liberal.
Yeah.
I think, these labels of being either liberal or conservative, I'll give you a simple example. If you grant bail, you are regarded as a liberal. Now, if you don't grant bail, should that very judge be regarded as conservative? What if it's a case involving, say, a brutal rape and murder of a minor girl? Judge doesn't grant bail. Does that judge then become a conservative? No, because, the decision to grant bail or not grant bail, of course, the liberty of the accused is of very significant importance. But you also look at the wider societal impact of the crime. For instance, as in the example that I gave you, if a young minor has been raped and murdered, then obviously the seriousness of the crime and its impact on society, on social security, is something which has to weigh in the mind of the court under decided cases.
So it happened with you when you were giving bail to like you said, A to Z, you have given
Yeah.
bail. So certain bails got appreciated, certain bails you got trolled for giving it. But there was the other thing which you got trolled when you said, I'm going to bring this up. I know you've explained it, but I'm going to ask you because some of our viewers may not know. When you said, I pray to a deity for a solution to the Ayodhya dispute. Now, uh, this was termed shocking, and that you asked for divine intervention. There were many views about it, whether it was what led you to make that decision that day. Was it because you prayed? So if you could explain
Well,
this to me.
like everything else on social media, what I said has been misconstrued. Because what you say is then sort of compressed into, a small short of 20 seconds. And what you said on a particular occasion is then put forth in 20 seconds as your view, which is not so. Now, I must tell you that when I spoke on that occasion, just before I laid down office, I went to my own village, which is about an hour and a half from Pune. It's a village called Kanersar, which is predominantly an agricultural community. And I thought I must go to my village. We have a old house built in the 18th century, which was there. And I thought I must go there and finally meet everyone before I lay down office. During the course of my conversation, a lot of youngsters asked me, we see you on YouTube. Many of them have now left the village, like I left, and so many other people have left. How is it that you maintain an element of calm in the midst of conflict? And that was what I was specifically asked to speak on. And I said, well, everybody has their own formula. Everyone has their own approach to life. For me, the time that I spend in prayer and meditation every morning is what ultimately sustains me as a person. Because, of course, I didn't say that you didn't have to apply the law, the constitution, to deciding individual cases. Obviously not. Even Ayodhya, the judgment of the court tells you whether the law and the constitution were applied or was it some divine intervention that was appealed to. So I think what I said on that occasion has been completely misconstrued. And I say so because what essentially I was saying was, and which I repeat, is that all judges work in areas of intense conflict throughout their working lives. It may be a dispute between two commercial interests, the standard case, in a commercial court, a dispute between two wings of the family, a spouse or spouses, disputes over child custody, disputes at a higher level between two levels of government, a state government and the central government, disputes over the sharing of river waters.
Capital punishment, even that would cause?
Yes, of course, because, something like capital punishment, a heinous offense, then you ask yourself, well, within the parameters which have been laid down by a court, can I say that this particular crime is so horrendous or that this particular criminal is so beyond redemption that the state can be justified in taking the life of that person? Now, obviously, if you are confirming the award of capital punishment, it's something which really deeply affects your mind. I know of colleagues to whom I've assigned capital punishment work who say that, well, if I've done 5 cases, it bears on you as a human being. So what is it that in the midst of this conflict, in the intense, social issues that you decide as a judge, that you find your sense of calm? And I don't make no bones about it. I practice my faith. I derive a great deal of comfort and solace from being a person who practices my faith. But what I want to also emphasize is that your ability to do justice in court and in terms of the constitution, the law, does not depend on whether you are an atheist. To be truly dispassionate, a judge does not have to be an atheist. You may be a person of a practicing faith, but yet you still do justice to every faith, people of all faiths who come before you.
Right.
And what is, ultimately, if you ask yourself this question, whichever faith you're talking about, what do all our faiths teach you about? They teach you about the universality of the human spirit. And if you really look at any faith that people practice, whether, it's my faith, it's somebody else's faith.
You respect all faiths.
I respect all faiths.
As an individual, and even when it comes in court, uh, the fact that you are a practicing Hindu doesn't in any manner interfere in your listening, in your hearing the other side, or
Absolutely.
person from another faith.
Absolutely. For the simple reason that there are two, if I can just break into a little bit of Hindi, there are two different concepts. One is the concept of being dharmic or being adhyatmic, and the other one is of dharm nirpekshata, which is that, your ability to be even-handed between people of different faiths. Because as judges, you are trained, you acquire this over a period of time, that you are applying the law to every case which comes before you. And the religion of a
Doesn't matter.
particular, it doesn't matter.
Right. But sir,
There are cases,
yeah.
there are cases, for instance, where, say, the caste of a person is a factor. For instance, suppose a Dalit, I had a case where a blind Dalit girl was raped. Now, I define that as a case of intersectional discrimination. The fact that that she was a Dalit, that she was disabled, and that she was subjected to gender violence, there, the caste does
Did
bear
play.
upon.
Correct.
Or if you're dealing with a question of, say, reservations, what is the true purpose of reservations? Is to bring the marginalized castes into the mainstream of our society. So obviously, in that sense, caste in that case does bear on the mind of the judge, because it's a part of social transformation, which the Constitution spoke about.
So, sir, you've read the papers today. You must have seen television yesterday. What happened in Uttar Pradesh with the mosque survey and the violence that happened later. So, there are many people. 3 people have died in the first wave of violence. Hopefully, it's under control. Now, there are legal stalwarts who have said that this is because of what happened with the Ayodhya judgment. So now even district judges are going to ignore the Places of Worship Act of 1993. So there's a bearing that happens. Like, it may not, but then judges will get affected, won't they?
Obviously, judges across the spectrum, have to understand that they are here to decide in terms of the law. And if there is a particular law which they have to apply, then they have to apply that law. And if there is an error on the part of a judge, that's capable of correction by a higher court. But, what I want to emphasize is this, that to start trolling judges, or to start criticizing judges merely because they have expressed that they belong to a particular faith, is, I think, not understanding the true nature of our social system, how our society works. You don't have to have a judge. For instance, someone once wrote, one of the commentators wrote that, well, it's all right if a judge practices their faith, but you sit in your own puja room in the midst of your house, close all the doors, and then pray. Well, I don't think that's a correct assessment. The very fact,
But sir, the Prime Minister came to your puja room and pictures of that went on social media, and then that happened with you, where they said that if he's so close to the Prime Minister, it's going to affect where the executive and the judiciary can't be separated.
Look at the work which we have done. I think assess us in terms of the work which we have done. I think something which is, a sociable visit, and this is not unique. Chief ministers, chief justices in the high courts, I've said this before, prime ministers visit the homes of judges on social occasions, sometimes on a sad occasion as well. This is the element of elementary social courtesy which is followed within the system. And, these social courtesies do not detract from the fact that despite these social courtesies which are observed at different levels of the government, in the work which we do, we are entirely independent of each other.
It doesn't matter. Like you began when you were talking about how careful a judge has to be in how he presents himself when he's out socially meeting with people. Does this trolling on social media and this intense scrutiny on how long you interact with the leader of the opposition and the prime minister, all this intense scrutiny, you being under constant photography, does that matter?
Well, there are times when you interact with the leader of the opposition as well. For instance, in many of our statutes require that a selection committee for appointment to a particular post must
he said.
consist of the Prime Minister,
Yeah.
the Chief Justice of India, and the leader of the opposition. Now, you discuss what you have to discuss, you arrive at your conclusions, and after you're done with those conclusions, you're human beings, right? You're going to spend 10 minutes after that having a cup of tea, talking about everything under the sun, from cricket to movies to
Does that
something.
happen? Do you chat?
Well, you talk about, somebody's visit overseas.
You're talking about the leader of the opposition and how you'd be chatting and things. But the opposition, he seems to have said this.
हम लोग अकेले आपका काम कर रहे हैं, इन्वेस्टिगेटिव एजेंसीज का काम कर रहे हैं, जुडिशरी का भी थोड़ा सा हो रहा है. तो रियलिटी हिंदुस्तान की ये है.
So he says the reality of India is that that the opposition is now tasked, or they have taken upon themselves to do the task of the media and the judiciary also, because they seem to have lost faith in that.
Well, I don't want to join issue with the leader of the opposition, because that's not the ambit of what we are here to speak. But what I want to say is this, that people should not presume that the judiciary should be performing the role of the opposition in parliament or the state legislatures. Too often there's a misconception that the judiciary has to play the role of the opposition in legislatures, which is not so. We are here to scrutinize laws. We are entrusted with the duty to scrutinize executive action on whether it is consistent with the law, whether it is consistent with the constitution. There's a different space in a democracy for the political opposition. And what people try to do is to use the judiciary and to shoot from the shoulders of the judiciary and to try and convert the court into a space for the political opposition. That is not the role
So
of
the
the
Maharashtra
court.
elections have just taken place, and the UBT Sena, they seem to say that history, and they have said this several times since, that history will not forgive Justice Chandrachud for the delay in giving the judgment and allowing the hijack of the party that it happened. It's the decision that was taken. He allowed, because of his judgment, this unfairness of people breaking away from the party, forming another government, and then so in delay and the judgment that you gave.
Well, my answer is very simple. You point out to us that we are not working even for a minute of the time that we are assigned to do our work, and such a criticism would be valid. Throughout this year, we were dealing with seminal constitutional cases, 9 judge bench decisions, 7 judge bench decisions, 5 judge bench decisions. Now, should any one party or individual decide what case the Supreme Court should hear? Sorry, that choice is for the Chief Justice. That these are, if you don't take up old cases, you are told, well, cases are languishing before the Supreme Court for 20 years. Important constitutional cases are pending before the Supreme Court for 20 years. Why is the Supreme Court not taking up these 20-year-old cases and dealing with some recent case? And then if you take up old cases, then you are told that, well, but you didn't take up this particular case. Well, you have limited manpower, and you have a given complement of judges. You have to draw the balance ultimately.
I don't want to take up cudgels on behalf of any political party, but like what the UBT says is that, I mean, it is one of our largest states. It is the richest state in the country. This is where is the financial capital is located. And political instability to a large extent, and they just keep saying they lost the election, yes, but they feel that that it broke the back of a major political party, the delay in your decision.
You see, this is the problem. The real problem is this, that a given segment of the polity feels that, well, you're independent if you follow my agenda.
Yeah.
That, you pursue my agenda, which is inclusive of cases which I think you should be deciding. We decided electoral bonds. Was that any less important?
Yeah.
It was a matter which dealt with the foundational structure.
Are you happy with that decision?
I'll come back to that in a moment.
Yeah.
We decided electoral bonds. That's one. We decided recently the Aligarh Muslim University case, the closure of the madrasas under an order of the Allahabad High Court. We have dealt with issues pertaining to the disability rights of individuals. Is disability in any way less significant than any of these cases that we are referring to? We have decided critical issues pertaining to the federal structure. This year, and these are all cases which we have decided this year, we decided the constitutional validity of Section 6A of the Citizenship Act, which gave citizenship to certain people who had migrated from Bangladesh prior to 25th of
yes.
March, not CA, who had migrated prior to 25th of March 1971.
Okay.
Was that less significant? We dealt with a case on whether, a constitution bench case on whether lakhs and lakhs of individuals belonging to not the highest strata of society, but the lower strata of society. The question was whether a person who has a license to drive a light motor vehicle can drive a transport vehicle below 7,500 kgs. Now, that would have affected the livelihoods of lakhs of people. We delivered judgment on that just before my term came to an end. Are these cases that we have decided? In fact, we decided 38 constitution bench references during my tenure, including this year itself. Are these cases any less significant than a particular case which we didn't decide or we couldn't decide?
Article 370, that also was...
Yes,
yeah.
yes, that's right. That we decided last year, but I'm talking of the cases we decided this very year. Now, the cases which we decided this year, any of these cases which I have referred to earlier, are these cases less significant, or do we then follow an agenda which others set for us that, well, you have to decide this case for me today. If you don't decide my case, then, well, you're not independent. This is something which is unacceptable. And the real problem today is this, and that's why, I must say this. It's because we have refused during my tenure as a Chief Justice. We have refused to be dictated by any third party on which cases to decide. Sometimes, very highly resourced persons come to the court and they try and suborn the system by saying, well, my case should be heard first. And this was a matter of concern to me as Chief Justice. Should we be listening to those cases only because the most resourced in terms of lawyers, in terms of the clients whom they represent, come to court and say, well, hear my case first? Sorry, we're not going to give that priority to people who are merely because they have resource and they have the ability to afford the best in terms of legal representation. When you sort of take cudgels for the system, for the ordinary Indian, and say this is not going to be how the court will work, obviously there's going to be a backlash.
Is there political pressure on the Supreme Court to take up certain cases by the ruling party?
No. In fact, you
didn't come under any pressure.
I don't think there was any pressure at all on what cases we should take up. In fact,
on Article 370, on Ayodhya, on Sabarimala, all these very, very important cases.
Look, Article 370 was pending before the Supreme Court for long, right? So if there was pressure, why did the Supreme Court wait for taking such a decision on that case? I mean, the decision came in 2019. The case was heard much, much later, several years later. And there's never the order in which cases are to be heard is decided by the Supreme Court and by the Chief Justice of India. There is no political pressure on which cases should be heard and which cases should be prioritized. That's entirely a matter for the judiciary to take up.
Was the process and the procedure appropriate on Article 370, the way it was done? Because there's a lot of criticism on that too.
Smita,
you don't want to go into individual?
I wouldn't know, for the reason that what we decided is up there.
Okay.
I'm not here either to defend my judgment or to critique the judgment. That's for others to do.
Does it bother you when you read the critique and you say, do you rethink and say that maybe did I do right, did I do wrong? Does that happen?
We've laid down the law, and once we've laid down the law, qua us, that is the law which we have laid down. And I know that, in any case that you decide after careful reflection, after considering rival arguments, and you take a decision which at that point of time when you decide is the correct decision. Now, future generations, in several cases, revisit judgments. For instance, I revisited the judgment
of your father.
Of my father in ADM Jabalpur, for instance, and we said that the judgment was wrong. or their judgment, on adultery. And we said that, well, the judgment of our Supreme Court, of our court on adultery was wrong. That's the churning process which
So when
takes
you
place.
revisited your father's judgment, did you get a call from home?
I was dictating the judgment at home.
Oh, okay. Did you feel that
Oh no, unfortunately, by the time I decided,
he was not.
my parents were gone.
Yeah.
But I must, again tell you something which is very personal. So when I dictated that segment of the judgment, when I came to the conclusion that my father's judgment in Saumitri Vishnu was wrong, it was, late evening. And after I completed that dictation, that part of the dictation, I just told my secretary, I said, Chetan, enough for the day. Because at a certain level, I knew I was overruling my father's judgment. I had to do what I had to do as a judge. But having done it, I said, well, I'm going to take a break for the day. That was all.
So, your father's a judge, you're a judge, your sons are lawyers. What is this thing about judges and lawyers? Why does this happen? Why? I mean, of course, it happens in the medical fraternity too. But why were you under any kind of pressure that I have to get into the legal profession? Were your sons under any pressure to get into it?
Well, speaking for myself, after I did my Bachelor of Arts in Economics and Mathematics,
St. Stephen's.
Yeah, from St. Stephen's, I decided to pursue a post-graduation in economics because I topped Delhi University and I was fascinated with economics. And I thought I should, perhaps consider doing a post-graduation
But before
in economics.
that, St. Columbus, you were what? Somebody was telling me, what pointer was it? You have these point system, right?
5-pointer.
5-pointer.
I actually got a 6.
6-pointer. You're the only 6-pointer or the
No,
first
we had a couple
6-pointer
of,
or something?
We had some other 6-pointers as well, and you had 5-pointers as well. So I was not the
I think
smartest kid on the
Shah Rukh Khan
block.
or somebody was
Anyway.
also, but later, much later, of course.
So, I decided to go into the law school because the classes at the Delhi School of Economics were to begin later. And I joined the campus law center saying that, well, I'll try and see what law is all about because, the law college began earlier. And having once entered the portals of the campus law center, there was no going back. We had a fascinating set of professors. I was just fascinated with the law, and then there was no question of going back.
But when your sons decided to become lawyers, they don't practice here when you were here.
Yeah, actually, my
one son is abroad.
He's
right?
abroad.
Yeah?
He's a barrister in London. The other one practices in Mumbai.
But will not come to Delhi when you are here.
Oh, absolutely. They both decided not to practice before the Supreme Court, or for that matter, in any court in Delhi, so long as I was a judge of the Supreme Court.
But then it does happen, right?
And I did the same thing too.
You didn't,
I didn't come to a court. In fact, the reason why, to be very honest, why I decided to pursue a post-graduation in law after finishing my law degree from the Campus Law Center was because my father told me that, well, you will not practice so long as I'm Chief Justice of India.
So you went to Harvard.
And that's how I started applying to universities, honestly, overseas. And I got a scholarship.
Yeah.
My father told me that, well, I have my entire provident fund, which is yours, because there's no better cause I can spend it on than your education. But it so happened that I got a scholarship.
And you got a job, which was not in a legal firm there.
Yeah.
Why did you come back?
Actually, when I got a job, nobody from India generally got jobs in law firms over there. The Koreans got jobs, the Japanese got jobs, Chinese, lawyers from Europe, say Germany or the UK, they got jobs in US law firms. But when you said you're from India at the interviews, they'd say, India who? India where? So Indians generally didn't get a job because, we were still a closed economy. The market reforms which took place in the 1990s were still to take place. And they didn't think it worth their while to recruit Indian lawyers for the reason that what was the countervailing benefit that they'd get. So I still landed a job at a Wall Street firm. But I decided to come back for a variety of reasons, actually. To be very honest, I came back for my parents. You're young, and my parents were, my father was just due to retire. My sister was based in the US, and I just felt that, there had to be one of us siblings who would be close to our parents to look after them.
And now that you've retired, would you like to stay on in India or leave? How does that work?
Well, let's see what life brings for
Life
me.
brings for you. Okay.
It's sometimes,
What
you
happens?
always, think you do something and then you do something completely different because
see,
life throws up different
About family
avenues.
matters, I have to ask you this because there are many lawyers who say that हमको तो cases मिलता नहीं है. It's judges के बेटे, उनको मिल जाता है. And this entire system that is, of even selecting seniors. If you are somebody's son, somebody's daughter, that's how you get picked. What do you have to say? That it's not unfair system.
Honestly, what you say does not lack the entirety of truth, but it has been my endeavor, both as a young judge of the High Court, later on as Chief Justice of the High Court, Judge of the Supreme Court and Chief Justice of India, to try and make the legal profession an equal opportunity profession. And you can do that in numerous ways. I'll just give you two examples. First, you spoke about designation of senior advocates. Between 1950, when the court was set up, the Supreme Court, and 2024, we had all of 13 women who were designated as senior counsel. This year in January, or February actually, we designated 12 women lawyers as senior counsel in one go. In August, when we did the second round, we designated, I think, 10 women lawyers as senior counsel. So we designated as many as, 12 plus 10, 22 women as senior counsel. None of them belong to legal families, or most of them didn't belong to legal families. Many of them were first-generation lawyers. And when we interviewed them, they told us their stories about where they came from. They came from small Tier 2 cities, Tier 3 cities, made their way to the Supreme Court, set up practice as first-generation lawyers. So I felt this is an enormous opportunity for us to change the way the profession is governed. I'll give you another example. All of us judges have judicial law clerks. And these judicial law clerks really assist us with research, but they are all young lawyers who've just passed out of law school. Now, the way the law clerks were typically recruited across the country was by word of mouth. And by word of mouth would often mean, a member of the bar saying, please take my son or take my daughter. And I said, this has to change. So I prepared a white paper during COVID. And it eventually gave rise to a policy which I adopted when I became Chief Justice of India. We have now been holding examinations at about 20 or 22 centers across India. So every young law student can appear for the exam irrespective of whether they are connected or networks for law clerks. Okay. And these are very highly prestigious positions because, of course, we pay them reasonably well. We pay them 80,000 rupees for the first year and 90,000 rupees for the second year, which is much more than what a normal lawyer would pay a young lawyer. But more than that, it gives you an opportunity to clerk with a judge. And so many of these law clerks then go abroad, they do their masters. My law clerks are all over the world now, and I take a great deal of pride in them. So what's happened is that as a result of our opening up our processes, it's ensured that people who are not connected with the law have an even chance of working with a judge. And working with a judge of the Supreme Court is an enormously prestigious thing for young. So these are things which you can do. So
two things which I have to discuss with you. One which you mentioned earlier, the Collegium System, and two is Pendency, which it'll be unfair that we're shooting in Delhi and we don't bring up the 84 riots and the long judicial process and still no justice. So that I'm going to come to. But before that, the Collegium System, where judges selecting judges, it's been criticized on the grounds that there is nepotism, it's an unfair process, and one of your quote when you said the Collegium System is not perfect, but it's the best available. Why is it the best available?
Right. Now, first and foremost, the perception that in the Collegium System, it's the judges who select judges is incorrect.
Okay.
The process of initiating the recommendations for appointments to the High Courts starts with the Chief Justice and the judges of the High Court, where they consult amongst each other and the judges of the High Court, and then they recommend people for appointment. But those recommendations are then vetted at various levels. For instance, the first level at which they are vetted is by the chief ministers and by the governors in the states. The files then move to the Government of India, where the files are then carefully reviewed by the Department of Justice. The Intelligence Bureau of the Government of India makes a very careful assessment of the credentials of the candidate, their antecedents, their character, their background. After that, once the inputs are put together by the Department of Justice, the file comes to the Collegium of the Supreme Court, where the consultee judges who have routed through that High Court are then consulted. So if it was a case for Bombay or Allahabad, two courts where I had worked before I entered the Collegium, my views as a consultee judge would be sought. It is after all this is done that the Supreme Court prepares its recommendations. So the process of appointment is a multi-layered process, particularly in a federal polity like India, where the actual appointment is processed at different levels in the system.
As compared to the American system, where it's completely political.
And in the American system, it is completely political, where the appointment of a judge of the Supreme Court comes up for confirmation before the Senate, and which is completely politicized. We don't work on that model.
Okay.
Also, we must understand that appointment to district judges, for instance, and which is the first level, the district judiciary, not district judges, but district judiciary, which is the first level of the system, is through a competitive examination process, which is conducted by the high courts or by the public service commissions in the states, as the case may be. As a result of that, almost 50 or sometimes 60% or more of the new recruits across India are now women who are entering the lowest levels of the judiciary, and they will obviously rise tomorrow and become high court judges, and some of them will come to the Supreme Court.
But if they don't have connections, will they get?
Absolutely. All these people who are appointed to the
examination system,
yes,
I get, but as they get higher,
makes
don't they
no
need
difference.
to have their connections?
Not in the least. They
Okay.
wouldn't have that, because that's the point, that your progression through the ladder is primarily based on seniority.
Okay.
Subject to having a good record. So, say a civil judge junior division will become a senior civil judge, then an additional district and sessions judge, a district judge, then a high court judge. And some of them, of course, can even come to the Supreme Court.
The pendency, crores of cases lying. What is the solution to this? More judges, more courts, what should be done? And do it quickly. I remember the first week when you came in and you spoke about this instance where you saw a woman who came to you and said, "Kuch kijiye, mere paas paise nahi hai." You spoke about this, and very evocatively, you said that you want this system to change where the poor have access to the judiciary. It's not just those who have resources, and quick judgments. Like, for example, in this one, he says it's a 40-year journey towards justice, the 1984 anti-Sikh riots, and nothing has been done. Victims are dead, dying, too old to care anymore. And, such a famous lawyer who says that the judiciary has failed to complete the process. All of us who have seen that as children, the 84 riots, just feel so helpless that kuch nahi hua uske liye.
What you say is there's a germ of truth in it. And what is the problem? What is the essence of the problem? First and foremost, the judge to population ratio in India is amongst the lowest in the world.
Yeah.
We do not have the number of judges which you require in the district judiciary to handle the kind of volume of caseload which is coming into the district judiciary. So first and foremost, you have to increase the judge to population ratio by appointing more judges.
Who will do that?
But appointing more judges is not just is just not a function of appointing more people, but having more qualified people who come in, which means that you have to identify more qualified people. Second, governments have to invest much more in infrastructure, which is not being done. Third, today, there are about 21% of the posts in the district judiciaries which are lying vacant. 27% is roughly the 27% is a vacancy in the staffing pattern of the district judiciary. Now, that is something in a federal polity which is handled by the high courts and by the public service commissions in certain states. Speaking for myself, I feel that one solution for the vacancies in the district judiciary is to have an all India judicial service examination, where the states would recruit, but there'll at least be one all India examination yearly, which will be held on schedule, And the people in that order of merit, and applying reservations, of course, as applicable to every state, would be selected by the states. So we have to find innovative
Have
solutions.
you recommended this?
This has been something which has been, but it will require constitutional amendment to my mind.
Okay.
Because, the recruitment and conditions of service of the judges to the district judiciary is controlled by the governors,
But
and
do you
obviously
feel it's
in consultation
imperative,
with the...
like you have police reforms, like you need admin reforms? If we are to become a developed nation within a span of time, I don't want to put a number to the number of years, but if we are to do that, don't you feel that
Oh,
it's
absolutely.
imperative?
It's imperative that we begin, and we have to begin at the base of the pyramid. And we need these judicial reforms at the base of the pyramid.
Okay.
We first and foremost need to fill up all positions which are vacant. Second, and that's something which people don't know, a lot of the delays which occur in the administration of criminal justice is due to reasons for which the judiciary has no control. For instance, service of summons and securing the presence of witnesses of the accused is not a function of the courts. And a large number of criminal cases remain pending on the docket of courts because the accused are absconding, or the witnesses don't appear on the day that the witnesses are supposed to appear. Now, this is not a function of the courts, because to secure their presence is not the function of the judge.
Who's then?
It's obviously the summons are served by the police machinery.
So that's where there's a problem.
Now, a lot of pendency of cases is just because of the fact that the accused is absconding or that the witnesses don't show up. Now, there is still an answer
like
to
in the
that.
84 case.
Now, there is still an answer to it. And that's an area which I had worked on extensively because I was chairing the E-Committee, which is to employ technology for more efficient functioning of the criminal justice administration. For instance, video conferencing. It was because of the video conferencing facilities that we had that our courts didn't shut down during COVID times, as courts in many other parts of the world shut down.
Yeah.
Now, we can apply video conferencing, which the new criminal laws do envisage, for recording evidence of witnesses. Say a person who has to, say an investigating officer who has to give evidence in a murder trial or in a rape trial.
Like in the Yasin Malik case also they
Right.
said that it can
So,
come up.
a police officer who is transferred by the time that, the evidence has to be given and is transferred to another district, that police officer can give evidence through video conferencing.
Okay.
Or a medical witness, say somebody who was recorded a dying declaration of a woman who was, say, allegedly burned for dowry. That medical officer can give evidence through video conferencing instead of having to leave their hospital and to go from one end of, say, Uttar Pradesh or Madhya Pradesh or Rajasthan to another end of the state. So technology can be used in very radical ways to expedite the process. When evidence is recorded, when the witness deposes in a court, the deposition of the witness is transcribed by the judge. The judge will dictate what the witness has said, and then that's taken down by a stenographer. That can be obviated simply by speech-to-text transcription. We have started that in the Supreme Court. In important constitutional cases, we have speech-to-text transcription of all the oral arguments. We have now a pilot module in place even for the e-courts project, which can be implemented in the district courts.
Hours can be saved per
Absolutely.
day.
So there is a lot that technology can bring in. Now, to give you another example, case categorization. You have cases which raise the same issue. Say land acquisition cases. There may be 2,000 cases relating to acquisition under the same notification. Case categorization has enabled us to identify which are those cases. Once we categorize those cases scientifically, those cases can then be taken up as a bunch of cases for decision making. Another important area which I'd like to share.
You can use AI in this, right?
Absolutely.
Yeah.
You can use AI not for actual decision making,
No,
but for the
categorization.
processual parts of our court work. Another area, for instance, where almost 50% of the time of a judge in our district judiciary is spent in roll calls of cases which will be adjourned because witnesses haven't shown up, because the service on the accused is not complete, or in a civil case, service on all the defendants is not complete. Why should these judges in the district judiciary across the spectrum be made to spend so much of time, fruitless, unproductive time, on these kind of procedural things, which can be easily farmed out to non-judicial personnel to ensure that the case will actually come to the judge only when it is ripe for
Judgment.
for
Instead of
no,
just
ripe for
postponing.
hearing, maybe the
Hearing,
interlocutory
okay.
hearing or the final hearing. So these structural reforms are extremely crucial if we have to have, in that sense, a modern judiciary.
Is somebody working on them? That's what I want
Absolutely.
to know. Okay.
I'll just give you an example on technology. On technology, we have now started e-filing of cases. Case records are being digitized across India. This has been a radical change. We have a 7,000 crore phase 3 of the e-courts project, which is being implemented at present. We send if you'd be surprised by the number of emails or the number of text messages which we send, which is unprecedented in any part of the world, in India, to litigants. We have ensured that litigants now have knowledge of what exactly is happening in their cases. And this is the case information software which we have developed as a homegrown software in India. So tremendous amount of work has been done in terms of incorporating technology in the judicial process.
So one of the complaints about the Supreme Court is that wealthy people hire the best lawyers. I spoke about that case where you
Right.
came in. And the poor people, they have legitimate grievances, but they're asked to approach the High Court first. Don't come to the Supreme Court. Like, go to the lower courts. Whereas if you have more resources, they come. You mentioned it too in one of your answers. What is the solution to this?
Well, you cannot ever prevent wealthy people from hiring good lawyers, right? That's a question of
Yeah, sure.
demand and supply and of
okay.
resources.
Huh.
But to say that, wealthy people get a hearing first in the Supreme Court when poor people are asked to go first to the High Court or the District Court is wrong. Irrespective of who is applying, say for bail, the same principle applies.
It also came up during the Arnab Goswami case that there are under trials who are languishing for almost a decade or more, but Arnab got a hearing.
Arnab's case came in appeal to the Supreme
In
Court.
appeal, yes.
He didn't come to the Supreme Court as a matter of first recourse. He went to the High Court. He failed in the High Court and then came in appeal to the Supreme Court, which is a matter of right. So also Zubair, when he came to the Supreme Court. That's why I said A to Z.
Yeah.
He came to the Supreme Court exercising his constitutional prerogative and the right which is available under Article 136 of the Constitution. But the answer to ensuring that poor people, less resourced people, also have qualified legal services is to strengthen the legal aid movement. We have the National Legal Services Authority, which is doing commendable work. The senior most judge of the Supreme Court heads the National Legal Services Authority, NALSA. Likewise, we have in the states the state legal services authorities. And we have the legal services movement, which has gone down to the districts. Now, the challenge before us is to ensure that legal aid ensures quality legal aid. And quality legal aid is really the key that even the most poor, particularly the under trials, who may not otherwise be aware of their rights, there are no takers for them, their families have sometimes distanced from them, they are entitled to the best quality of legal services.
Can there be, like, say, in the American system that, all cases don't necessarily need to come to the Supreme Court, that, certain cases you deal with at the lower courts and they're done with, like, say, divorce cases or whatever. You're done with the lower courts and that's where it ends. Is that a solution?
That could be a solution, but that's not the model our Constitution followed.
Okay.
Our Constitution created, and with a great sense of vision in when the Constitution was being drafted, an open access to justice model. So we have Article 136 of the Constitution, in terms of which an order which has been passed by any court or tribunal in the country can be the subject matter of a special leave petition. Now, if you restrict access to justice, that creates its own problems.
Sure.
Because then what would happen is, especially, the deflection from justice occurs the most in the case of those who don't afford good legal services. And if we were to follow that model, say, which has been followed in many of the Western countries, that would really, in that sense, detract from the cause of justice to the...
It's double-edged, right? Like, you want instant, or you want justice, but you don't want pendency. So, in both ways, I feel argument is strong.
I want to emphasize that, the Supreme Court is not a court for the resourced. It's not a court for the rich. It's a court which deals with the problems of the poor.
It ought not to be, or is not?
Is not.
You feel
is
that?
not. It isn't.
Okay.
Because it's someone who has worked in the Supreme Court as a judge, as a lawyer, who will tell you that. Because, you have benches after benches of the Supreme Court dealing with bail applications of the smallest persons. In the last 2 years that I was a judge of the Supreme Court, 21,000 bail applications were filed. These were bail applications of common citizens. We disposed of 21,358 bail applications.
In your 2 years?
In my 2 years. Much more than what was filed.
Okay.
And those are bail applications involving small, many of them very, very ordinary citizens who have, cases of cheating, cases under the NDPS Act, cases involving, assault,
But there are
small
personal liberty
offences.
cases also. You've spoken about personal liberty a great deal.
Yes.
In that. Could you tell me about those cases also which are pending, which many people feel that it comes up and then they don't get bail?
Well, I must tell you that, over the last 2 years, we followed this procedure. I ensured that every day of the week, every single judge deals with a certain number of transfer petitions. Those are typically matrimonial cases. And a certain number of bail petitions. So at least about 15 cases per day between transfer and bail petitions were heard by every bench of the Supreme Court. Which was, we prioritized cases involving bail and habeas corpus. That is why you have these figures, where the actual disposal of bail applications was much more than what was filed. Now, whether bail should be granted in a particular case to an individual is a matter for that judge or that bench to decide. That bench may, on a scrutiny of the record, may feel it's a case for the grant of bail to protect personal liberty. A bench may feel that by granting bail, I would be detracting from the social interest, the interests of society in prosecuting for crime. If it's a heinous offense, a bench may well feel that I don't want to grant bail.
Because
that's a call for that bench to take.
Because in this case, there are a number of people who feel that, there are, with regard to the CAA protests, there are many people who are still languishing since then. It's been unfair. I mean, of course, there are people who will say that it's because of religious reasons. Then, because they are Muslims, that's why they don't get a
Again,
fair
that's
hearing.
not a correct perception. If you see the number of people across communities who grant bail, who are granted bail, and that has nothing to do with the religion of a particular person. But as I said, whether to grant bail in an individual case is for that bench or that judge to take at that particular point of time. The concern which I have, however, which I have made clear earlier, is that district courts today, there is a reluctance to grant bail. And the reason for that is this culture of mistrust in our society. Because district judges are worried about the fact that if I grant bail, will there be an allegation against me that I have granted bail for extraneous reasons? And I've always said that, well, we as judges of the superior courts have to protect our judges at the lowest echelons of the pyramid. If a judge in the district judiciary grants bail incorrectly, obviously it's capable of correction by a higher forum. But let's not then target judges who have granted bail.
Okay.
Right?
Protection
Because,
how, sir? In the sense
in
of
the
physical protection,
no, not
social
physical
media.
No,
what
yeah.
is
So
the
not just social media, but there is a fear in the minds of judges in the district judiciary that if they grant bail and their order of bail is then set aside by a higher court, there will be strictures which will be passed against them. So
Are they passed?
we generally lived, yes, of course, they have been passed, and we generally live in a culture of mistrust. That is why, for instance, government officers don't want to take a decision that, well, don't file an appeal to the Supreme Court. There's nothing in this case. Everybody says file an appeal to the Supreme Court because nobody wants to say, well, I took a decision not to challenge the case higher, which results in frivolous filings before the Supreme Court. The same culture of mistrust then affects the district judiciary.
Okay.
And I think that's not so much a product of the law as a product of the times in which we live. And we have tried to send the message across that cases where bail should be granted by the district court must be granted by the district court. We find very often that cases where bail should be granted by the High Court land up in the lap of the Supreme Court. And we very often ask, why did the High Court not grant bail in this case? So across the system, I think this message that bail must be granted and that bail is the rule must be followed. Having said that, equally, we must grant the discretion to individual judges to take the call that this is not a fit and proper case for the grant of bail. Every case does not necessitate the grant of bail. A case, there are well-settled parameters where the crime is of such a heinous nature. There's an apprehension that the accused may abscond or may not be available for trial, or that the witnesses may be tampered with in the course of the trial if bail were to be granted. So courts do have that residual discretion on whether or not to grant bail, which is a matter for individual judges to take a call on.
Internationally, some of the judgments that when you were in the Supreme Court that came up was the decriminalization of homosexuality, and several cases, when it came have come up. But this especially, Americans were watching what happened, the rights of LGBTQI, them. And as I said on the termination of pregnancy, these are things which internationally they were looking at Indian courts. Did you realize at that time when these decisions were taking that it's going to have ramifications beyond the borders, geographical borders of the country? People abroad are also watching it.
Well, I learned, of course, from my readings that, there was a great deal of interest in these issues. But there again, the issue of queer rights, the LGBTQ plus population, their rights, and medical termination of pregnancy are two different issues. On decriminalizing homosexuality, as you know, we took a call that the provisions of Section 377 of the Penal Code, which made it an offense to engage in carnal intercourse against the order of nature. That was a word, that's a phrase which was used. That was unconstitutional because, as between adults engaging in consensual relationships of the same gender, having decriminalized homosexuality, which was again a judgment which was widely reported across the globe. Our judgment was followed in different jurisdictions across the world, at least cited in different jurisdictions. Whether it was followed or not was ultimately a different issue. The next step that the movement sought to pursue in the Supreme Court was the right to marriage equality. They said, well, people of engaging in same-sex relationships should have a legal right to marry within the purview of the Special Marriage Act. And there we said that, well, whether the right to marry should be recognized or not is a function of Parliament, because the Special Marriage Act used the expression man and woman. And we said that we can't substitute the word man and woman for man and man or woman and woman.
So that has to be done in the legislature.
That has to be done by legislation. I was partially in a minority because in my minority judgment, Justice Sanjay Kaul and I, we said that, well, even if we don't recognize the right to marry, we must recognize the right to form civil unions, which the majority felt that you can't do by a dictate or diktat of the Supreme Court. But then that again begs
What's
the question.
Difference?
A civil union. Marriage is a union which is recognized by the law as marriage postulates, a relationship which either follows under the Special Marriage Act, by virtue of which, it's a relationship which parties enter into by a legal form, or by your personal laws. Like
so in civil union, there's no rights?
No. In a civil union, there may be certain rights, but not all the rights which follow upon
So
marriage.
Inheritance doesn't come?
In a civil union, possibly no, unless, again, the law. That's exactly the point which we made in our judgment. That, marriage is not just a matter of entering upon a relationship which is within the fold of law. That has consequences in other areas like inheritance, succession, adoption, so on and so forth. And therefore, it was much too complex for the court to legislate upon. It was essentially a function of Parliament. But we felt that at least let's recognize the right of two adults of the same gender or the same sex who want to enter upon a union to cohabit together. Because that itself will give social recognition of the right to cohabit and to form unions. And then perhaps at a later point of time, Parliament can intervene. On the other area that you referred to, namely the medical termination of pregnancy, our law is much ahead of the laws in other parts of the world. For instance, our law recognizes the right of every woman to terminate a pregnancy up to 20 weeks, and then between 20 and 24 weeks on the advice of two medical practitioners. And by interpretation, we have gone much further.
Yes.
For instance, an unmarried woman had the right to terminate up to 20 weeks. We said in our judgment, which I delivered, that there is no difference between the right of an unmarried woman and a married woman between 20 and 24 weeks. And you can terminate even up to 24 weeks if you are if a person is an unmarried woman. Significantly, our law permits termination of pregnancies even beyond 24 weeks in the event that the child has certain congenital abnormalities. So in that sense, we have gone far beyond, say, the position in the United States, where the US Supreme Court reversed its judgment in Roe versus Wade. So in that sense, our law is far ahead of the curve than in most parts of the world.
You would be following that, right? You've practiced law in the US, you've practiced law in India. When I talk about Roe and Wade, I'll ask you this, that when you were doing that judgment, did you think about Roe and Wade at that time? Did you think about, because you've studied law there, you've practiced law there. So does that factor in?
Well, I was aware of Roe versus Wade, but we were applying the parameters of our own law. Namely, we have the Medical Termination of Pregnancy Act of 1971 enacted by Parliament. So we were applying purely a legal standard under our law, guided by the principles of our constitution, which speak of the autonomy, bodily autonomy of a woman, liberty, the right to fair treatment, so on and so forth under the constitution.
And this is regardless of which religion the woman, the mother is from, right?
Absolutely. It's agnostic to religion. That law gives the same rights to every woman.
Was there pressure on you, sir, when you were delivering these kind of judgments, which are going to impact even on, when you talk about marriage, there are interest groups from various religions. Is there pressure on you at that stage, when it's the madarsa thing, when it is this triple talaq, these kind of
not at all.
judgments?
I mean, when you're dealing with, say, a medical termination of pregnancy, the religion of the woman, it doesn't even enter into your mental calculus, because you have a case, you apply the law which has been enacted by Parliament, and then you stretch the boundaries of the law to the extent that is feasible in terms of principles of judicial interpretation to provide justice in individual fact situations. There's absolutely no question of any pressure. That's what the judicial function is all about.
Where it doesn't matter, yeah?
Yeah, absolutely. Otherwise, these judgments wouldn't have been delivered in the first place.
Another thing which I want to ask you is making our courts disabled-friendly. I want to ask you, because you've taken so many measures on this matter, it's personal to you also.
Yeah.
Explain that to me.
Well, I wouldn't begin with why it is personal to me first. I'll speak as a former judge. We have a very unique piece of legislation in India, which is the Rights of Persons with Disabilities Act, and which speaks of reasonable accommodation to individuals. And we've applied those norms. I've had a case where someone with a writer's cramp wanted additional time, and we sort of developed a whole theory of reasonable accommodation. We had a petition recently which came up where there was a very pejorative portrayal in the visual media, in a film, of disability humor, as it was called. And we then tried to distinguish between disability humor, which is acceptable and which is not acceptable within the framework of Article 19(1)(a) of the Constitution. Just before I retired, we had this young student who was 88% disabled and who wanted to secure medical admission for the MBBS degree course, and was rejected on the ground that, well, he'll not be able to pursue medical studies. And we had him reassessed by a very competent disability professional and directed that admission should be granted to him. On the administrative side, I had an accessibility audit conducted of the Supreme Court premises by one of my colleagues, and that resulted in an accessibility report. And we have tried to implement the accessibility audit report in making the Supreme Court more disabled friendly. We've opened the Mitti Cafe in the Supreme Court, which is a cafe which is run exclusively by individuals who are disabled. In fact, we have a young couple in the cafe who got married after they met each other in another cafe. But all of them are running the cafe. The idea is to send a message across to society that they're capable of leading independent lives in dignity like all of us in society. It has a lot of meaning for me personally because Kalpana and I have two wonderful young girls who've come into our life when I was Chief Justice of the Allahabad High Court. They originally belonged to Uttarakhand, and I think they adopted us. As I always say, our paths crossed and they're part of our life. They're with us, Priyanka and Mahi. They are 16 and 14, and they've been with us for nearly a decade now.
Did it make you like more sensitive towards this? Because it's so cut and dry, and when you're dealing with certain issues, but if in your personal life you're experiencing all this.
Yes, of course. I mean, it's after all our personal experiences as human beings which shape the way you respond to issues. I mean, the fact that I live with two specially abled children who are our own affects the way I look at disability, and that's part of how I've tried to portray disability as not a medical issue, but a social issue. The barriers on the disabled are barriers which society imposes. They are capable of leading adequate and fruitful lives.
Do your daughters watch you on TV now that the proceedings are live? Do they watch you?
Yeah, they watch me.
Yeah.
They watch me. They tell me when I'm trolled. They've come to my court. I've
Okay.
brought them into my court. They've come and seen my chamber in the Supreme Court.
Okay.
And they're intrinsic part of our lives for Kalpana and me.
So they follow you on
Yeah.
follow the things on social media.
And
which are written.
honestly, they've changed the way I look at the world and Kalpana looks at the world. For the last 10 years, they are both very deeply into the environment, into leading a cruelty-free life.
Okay.
And our younger daughter, Mahi, was, prevailing upon us, persuading us for almost the last several years that we should, be vegans. And the fact that we turned vegan has a lot to do with, what we received from them in terms of ideas, video clippings, news articles, stories on the print media, on the electronic media that they've been reading. That's played a very important role in why we have adopted a cruelty-free lifestyle.
Yes, I believe you're proponents of Ayurveda, and
Yeah.
you don't buy silk also
Yeah.
because you feel that is. Could you explain that to me also?
Being vegan is not just being about being vegan in diet, which is being a person who follows a vegan or a vegan diet, but it's also being about being vegan in your lifestyle. What you eat is, of course, plant-based. When you're a vegan, you follow a plant-based diet, which is you don't have anything which would have its origin in an animal. So obviously you don't eat meat, or
Okay.
you don't, but you don't even have a milk product, an animal product like milk or honey, which is again has its origin in the bees. So, but vegan is also about following a cruelty-free lifestyle. So you don't wear silk, for that matter, leather. Now, what Kalpana and I have decided is that we are not going to throw out what we have. We've spoken to people who are vegans across India and different parts of the world. It's also a question of resources. So what we have, we are not discarding, in the sense that, she may have a sari which has been given to her by her mother 25 years ago. So you're not going to dump it into the waste paper basket. But she's stopped buying any new silk product or any new leather product.
And Ayurveda also, I believe you use Ayurveda products, and you're a
Absolutely.
proponent of Ayurveda.
I'm a proponent of Ayurveda. I follow there's this wonderful Ayush hospital, which is under the auspices of the Ministry of Ayush. They have some amazing doctors. And interestingly, Ayurveda is now fanned out across the world. In Germany, in Switzerland, different parts of the Korea. You just name the country and there's a huge Ayurveda movement going around in different
Does
parts
this
of the
all
world.
impact on your mental abilities, capacities? Does it keep you more grounded, you feel, by eliminating, people say there are toxins in your diet, in daily life that we consume?
I think what you ingest into your mouth, and that's my own personal experience. I'm not speaking as a doctor, but just as a human being. So I don't want to make any scientific statements. But what you ingest in your mouth and therefore in your body affects the kind of person that you are. And I think gradually, adopting a more holistic pattern of living has made me a calmer person. I think more rooted, I feel, to reality.
Did you get upset at all when you read articles about you, when you saw criticism about certain things, certain decisions take? How do you keep your emotions in control?
Well, momentarily, yes. As a human being, it would be very far-fetched to say that you don't get affected or you're not upset. But I said momentarily. I just let it pass, and I just let it out of my system. And that's something I've learned over a course of years. That things which people who tend to hurt you and people who say nasty things. And I believe that the best answer is to not let it affect your system and just let it out of the system. And
How
then
do you let it
continue
out?
to.
Do you vent at all?
Uh, Not necessary, because if you believe in yourself and if you believe in the work which you do, in the choices which you make in life, you realize that doesn't matter to you ultimately.
For example, say the Article 370 judgment. You know that the political establishment in Jammu Kashmir was very angry, and they felt that the judiciary had let them down. They came, they appealed, all that happened. Then when you meet, say, a Farooq Abdullah, and he blamed you personally, how is that interaction happening then?
Well, I think the way I look at it is that, well, I'm doing my duty and my function, which destiny has assigned to me. Perhaps he's doing his part of his role in the nation.
So it's karma and dharma that you talk.
In what destiny has assigned to him. So who am I to either criticize or look at him with disdain? He has a role in the universe. When I say he, people like him, I say. I'm not talking of an individual particularly. I have my own role to play in the universe, and I do mine. I fulfill my own function and let other people do theirs. And I think not to be affected by events which are happening in your life at a particular given point of time, and let things be, is, I think, my own
There's
mantra.
a great deal of equanimity that while talking to you, that one sees. You're not given to becoming excitable or angry. Usually lawyers are like that. Pardon me for saying this, but it is there. But you're very, that is, to say that about you, I mean, once.
I can't say that I was like this always. I mean, there are periods in life when you are that angry young man when you are 16,
Okay.
as your parents joke
Were
with
you
you.
like that? Were you?
Not really, but to a certain extent, yes. I mean,
Okay.
you're passing through a period of adolescence and, that kind of period. So I've been like any other normal kid around the block. But I think, over a period of time, you go through a whole cycle of life and the experiences of life. They teach you something constantly.
Would you be
And,
interested ever in joining politics? And what do you have to say about judges who didn't keep that little period of time between being a judge and then joining politics immediately?
I've looked at people who've been in politics over my career, and even before that, when I was a lawyer. And politics is very serious business, and it's a difficult art and science. And therefore, I respect those in the political spectrum of the nation for the kind of work which they do. In so many which ways, I feel that, the work which I did as a judge or as a lawyer was in many ways so much easier because, I was with myself, with my files, my books, my judgments, dealing with society. It's easier from a certain perspective and it's far more difficult from a certain perspective. They're two different institutions in a democracy which we have to respect. But speaking for myself, it's a completely different universe. For instance, when I would speak to the law minister, when we'd be discussing judicial appointments, I'd always tell him that, with kind of schedules which you have of being all over the country, I wouldn't be able to ever do that. I mean, I love my time when I'm in my study, working on my briefs, working on my cases for the next day, working on judgments. That brings me real fulfillment as a human being. So they are two different lifestyles
So
completely.
if it's not for you, you're saying, but at present, maybe at some point of time it will be, but are you averse to the idea of judges joining politics? No.
I've answered this question historically. One of the greatest judges in India, Justice K. Subbarao, his judgments are cited even today before us, and he spoke with such perspicacity at the time when he wrote. He resigned from the Supreme Court to contest the presidential election. So, Justice Subbarao took a call to then contest the election. It was a different time. He lived in his times, and he took a decision which was perhaps valid from his point of view at that time. You've had other judges of the former judges of the Supreme Court who then contested elections. You've had judges from the high courts who've done that. My own belief, however, is this, that when you lay down office as a judge, people do continue to assess you from the standpoint of being regarded as a judge. And it's important that all judges who have occupied that post to understand that. Because in what you do after you cease to be a judge, you should not affect the credibility of the work which you did as a judge or the credibility of the institution which you occupied. I mean, what am I but for the fact that the judiciary has made me what I am today, former Chief Justice of India? I mean, take that away from me and I'd say, what am I left with? So, as a judge after retirement, as a former judge, I shouldn't be doing something which would bring any form of a credibility crisis to my own institution, which I have occupied.
Would that happen?
But I wouldn't at all criticize colleagues, former colleagues, who have taken an alternate path. It's for them to take a call. And I'm no one to criticize them.
But
some of them,
by doing that, do you think that they've brought some kind of a disrepute or some kind of a questioning, at least, about the impartiality of the judicial system in India?
Well, to be very honest, I don't think I don't think it would be fair to say that their decisions post-retirement brought into question the decisions which they took while they were holding office.
Okay.
For the reason that a decision of the Supreme Court particularly is not a decision of one judge. It's a decision of a collective body of judges. It may be a decision of a bench of 2 judges, a judgment of 3 judges, of 5 or 7. To say that, well, because one of the judges on the bench after retirement joined politics brings the judgment into disrepute is casting aspersion on every other member of that bench as well. So it doesn't work that way.
Okay.
It doesn't work that way at all. Because after all, every decision that we take is being taken by a group of judges. And the more important constitutional cases by at least 5 judges, and sometimes 7 or sometimes 9. So to say that, well, that judge's decision post-retirement had some bearing on the decision which that judge took would be unfair a criticism, because that
Okay.
would be a criticism of all the other judges who are part of that bench.
So there's one
So
question
that is something which
Okay.
we must not ignore as well.
One of the questions which my team had was on the Supreme Court's prison report of October 2024, which
Yes.
recommends using electronic tracking devices for under-trial prisoners to be released on bail. What is your view on this?
Well, the prison report was the product. We have the Center for Research and Planning in the Supreme Court, which is manned by some amazing young people. We have about 20 young lawyers who I recruited, in the Center for Research and Planning from different parts of the country. Again, first generation lawyers, from Jammu and Kashmir to Lucknow, to Tamil Nadu. They come from all over the country and work on these cutting-edge ideas. So the report of the Center for Research and Planning is not necessarily the view of every one of the 34 judges of the Supreme Court.
Okay.
It's a report it's the think tank of the Supreme Court, and we put that report across. One of you've dealt with this issue, of course. You've asked me about, the tracking of criminals under trials by the use of electronic technology. Another thing which the prison report has dealt with, which I myself dealt with in a judgment which we delivered a couple of weeks or maybe a month before I retired, was about caste-based discrimination in the prisons. 75 years after independence, what work an under trial or a convict does in a prison is in many prison manuals determined by the caste of that person.
Like the cooking is done by people of certain
Castes. then the sanitation work is done by. We said that has to end in prisons.
Yeah.
That can have no role to play in independent
Frankly,
India.
people didn't even know about it till this report came out.
Absolutely. And our attention was drawn by a news report in the electronic media, which was converted into a writ petition, and then it came up before us.
Yeah.
And this report has taken it to a different level by looking at the prison system across the spectrum. Now, on your question on the use of electronic tracking technology, there are two views on it. And therefore, it requires, stakeholder consultation. One is that, by using these means of tracking, you can ensure that you don't have to fill up your prisons with petty criminals who shouldn't be there for small crimes. You can let them out and ensure that they are not absconding or they are available to face trial. At the same time, they are free, and our prison system is declogged, which is the need of the hour.
Yeah.
The other issue, which of course is raised, is about privacy. And how do you draw that balance between privacy and the need for declogging the prisons? Privacy, because if that kind of an individual is even with a partner, there would be an electronic record of who that person is, what that person is doing at a given point of time. So obviously, there's a need to balance.
But in this day and age, you can put a chip or something in a person, right? Doesn't have
Yeah.
to be a tracking device as such.
Yeah, but even that chip would give you exact details
Location.
of location, what that person is doing,
Yeah.
at what point of time. So in that sense, there are also privacy concerns which need to be balanced. What I'm saying is that this is obviously something which requires greater deliberation. We've put that in the public realm as a possible alternative to having more and more people being situated in prisons, and then place it for wider societal deliberation. I've just flagged the two countervailing viewpoints.
Okay.
And it requires something of a more candid deliberation, both within and outside the judiciary, including by the lawmakers.
There's a lot of debate now about these privacy issues which are going to come up, especially as apps are coming into the country. Do we keep the servers within the country, keep it outside? You're a nerd, so you would know about all these things, right? You know about technology. You're a great one for that. These topics are going to come in courts now. Do you think that our judges are tech savvy enough to understand all this? Do we need our judges to know more about technology, to understand all this? Because of all these, you have several cases which are pending in court right now.
Answer to the first question, are our judges adequately tech savvy to find answers to this? Answer is no. What's the answer then? In a court, you have rival viewpoints. People present data to you. They present information to you. But equally, there's a need for judicial training, because our judges must understand what is the role of technology which is being played in our social life today. It's very important that judges are adequately equipped with the kind of information which is necessary. I was aware of some of the pitfalls. Therefore, for instance, in the e-courts project, I set up a committee of domain experts who dealt with data privacy and data security. How do we ensure? I mean, the data which we have in our possession today is data of the entire nation, of our citizens, of their relationships, of their orientation, of their ideologies, their beliefs, so on and so forth. So a decision which we took was that, the data which we store, which should be stored in a cloud which is not beyond our sovereign control. So the cloud which we store our data on is a cloud within and not without or outside the country. But there are serious issues of data privacy and data security.
You've spoken about it several times on this
Absolutely.
issue. There needs
And
to be more work done on this.
there needs to be more work done. And in that, I believe the judiciary cannot stand alone away from the other arms of the state. We have to have a consistent national policy. Because in that sense, the judiciary is not, a standalone feature of the nation state. We also have very sensitive data, say, about defense, about finance, about securities. Now, how are we ensuring that this data, the integrity of this data is maintained by the nation? So there has to be, in that sense, a comprehensive national policy. But short of that policy being formulated, we have been trying to do what we have to do as judges to ensure that,
When
we
you were
maintain.
introducing the e-course, when you were bringing in the live telecast and then bar and bench and live law, the reporting, all that's happening. Was there resistance from your own community at that stage? Mat karo ye sab. Why are you opening it all up?
Well, yes and no.
Okay.
In the sense that, but I think overall, of course, there was first the judgment of the Supreme Court in Swapnil Tripathi, which was a judgment on the judicial side, which said and spoke of the importance of live streaming. Now, so that gave us, and I was a party to that judgment. It was Justice Deepak Mishra, Justice Khanwilkar, and me. So that gave a sort of a judicial way forward, the path forward. But obviously, there are, and that's the beauty of the Indian judiciary, that you have people with different perspectives. Not everybody is as involved in a technology as, say, I was, or some of the younger judges in the high courts are. But overall, now there's a realization that technology has a great deal to play, a great role to play in terms of the efficiency of our system, of the outreach of the Indian judiciary towards our people. There are 37,000 judgments of the Supreme Court since independence. All the 37,000 judgments have been translated into Hindi using machine-assisted, AI-assisted learning. And all these judgments are being translated into every language which is recognized by the Constitution using AI-assisted machine learning. We have a software called Suwas, and that's work in progress. So the idea of doing this is really to reach out to people, to enable people to understand in a language which they speak. Can you imagine a judgment on labor or service or motor accident is intended to provide justice to the citizen? But if a citizen doesn't understand English, good heavens, what's the worth of that judgment to that citizen? So we are therefore trying to translate these judgments, in which we are doing already. We've done that for Hindi completely, to allow for a comprehensive and comprehensible understanding of our work by our own citizens.
So you realize that when you came in 2 years ago, it was this nerdy, liberal, woke judge, darling of the liberal masses, and then comes the Ayodhya judgment, and then you become, and you say that you prayed, and then you become this conservative. Suddenly you become a villain for the liberals, and you become the darling of the conservatives. How did that happen?
But
And did you realize it happened?
These labels of liberal and conservative, I don't accept them, because these are political labels, and they postulate that a judge must be on one end of the political spectrum, either as a liberal or a political, or a liberal or conservative. And these are ideologies. That's not how judges decide, right? You look at my track record, and I'm not going to speak about the track record. You will find judgments which are interspersed, which protect human rights. And then you may have judgments which, in a certain area of law, say taxation, take a more conservative viewpoint. And then you will have judgments thereafter which take what, quote unquote, may appear to be a more liberal perspective.
GST was also during your time, right?
GST was during my time. One of the last judgments which I delivered was in the Aligarh Muslim University case, or the Madrasa case, which was 2 days before I retired. So you cannot look at the life of a judge as being either on the liberal end of the spectrum or the conservative end of the spectrum, where you are judges not chosen for political reasons. We are unlike the American system, where judges are not political appointees. We are career judges. We were drawn from the bar, or people who come from the district judiciary. We are essentially career judges. So you look at that particular case and decide that particular case and see where the balance of justice lies.
Do you revisit, personally, when you go back home, do you revisit a judgment, say, delivered a few years ago, and say, maybe at this time, with the information I have now, I might have...
Well, very often your own judgments are cited before you. So I have judgments of mine which are of 2016 which are cited before me, or were cited before me, or 2018. And when a passage is cited, obviously, it's a thinking mind. So I always ask myself, could I have reframed this passage in this particular way to bring greater clarity to what I wanted to say? That's a human process which goes on all the time.
But reverse a judgment?
If I had to reverse a judgment of my own, I wouldn't stop short of reversing a judgment which I had delivered. If I felt later, say in review, that, a judgment which I delivered required to be, corrected, I would have done it, because, that's the jurisdiction in review which you have. Or if I was sitting in a larger bench and I had to revisit my own judgment, Well, I wouldn't
You
stop
wouldn't
short
hesitate.
of doing it.
But
That's your duty as a judge to do that.
so we were talking about political pressure, and when you were in the Allahabad High Court, you were really young. Was it easier for politician to pressurize a young judge at that stage?
Oh, no, not at all. I don't think age has anything to do with it.
Really? Okay.
Absolutely, age has nothing to do with it.
तो
And
ये
that's
तो
what I
अभी
said.
छोटा है, इसको pressure डालो. Was
नहीं,
that
पर
there?
छोटा है नहीं, 53 साल का था मैं उस समय. I was 53 years old,
Well,
you know.
compared
I
to
mean,
what is happening. Okay.
So when I became Chief Justice of the Allahabad High Court, and again, that's what I've said, on this whole issue of, the engagement on the social level between the political arm of the state and the judiciary. When my mother passed away I was the Chief Justice of the Allahabad High Court. She passed away in Mumbai. When I got back to Allahabad, the Chief Minister and his wife took an appointment and came and just spent 10 minutes
was
with me. Mr. Akhilesh Yadav was the Chief Minister.
Okay.
He dropped in. I was in Lucknow. I had gone to Lucknow from Mumbai. We have two, as you know, we have two seats. The main seat is in Allahabad and a bench at Lucknow. I was sitting at Lucknow and there was a request that the Chief Minister and his wife would like to come and visit you. I said, certainly, they can come and visit you. So they spoke about my parents, from whatever little they knew about my father and things like that. So these are just...
But there was a time that was a very difficult period for the legislature and the judiciary at that time. It came up, number of cases came up where they were, hammer and tongs against each other during that period. In spite of that, these social pleasantries happen.
Well, of course, absolutely. And that I do believe that speaks about the maturity of the system. And irrespective of who is in
because he was
government,
also very young
and
as a chief minister.
Irrespective of who is which political party is in power. That was one political party. When I was a senior judge of the Bombay High Court, there was another political party which was ruling in the state. And these are social niceties which are followed, and that has nothing to do with the way you decide cases. And that's the way it is maintained.
Because, the normal public, they say, oh, ye Congressy judge hai, ye BJP judge hai, ye right-wing judge hai, ye left-wing judge hai. This is how people talk. Is that really the case that happens?
कहने वाले कहते रहेंगे, but that's not the way it happens.
It doesn't?
I'll tell you one thing. When we were lawyers, we knew that, if I went to a particular judge, for instance, this judge was a little more compassionate towards labor, right? I would know that, if I went to a particular judge in a particular court, that particular judge was a little more compassionate towards the cause of tenants. Or agricultural tenants. Now, that's part of the human process, that someone has a degree of understanding for the weaker element in society. That's very different. But in terms of political ideologies, absolutely incorrect. I mean, there's no question about it.
The caste element, there are times when a caste-related issue comes up, and if the judge sitting in front of you is clearly wearing a caste denomination on his forehead or on his anywhere, his wrist or whatever, does that impact in any manner when the lawyer is arguing that half my battle is already lost?
That's why the system has corrective remedies. I don't subscribe to the view that, judges decide cases on the basis of caste, except when marginalization is made a factor by the Constitution, right? So when you say, for instance, dealing with the need for greater inclusion of marginalized groups of society like the scheduled castes into the mainstream, there the Constitution mandates that you must look into marginalization as a social factor, as a constitutional factor. Otherwise, judges don't decide, a criminal appeal on the basis of caste. Whether a person has committed murder or rape is decided on the basis of the evidence which was before the court, not on the basis of the caste to which that person belongs. It just doesn't happen that way. But assuming for a moment that there is a deflection of justice or an error committed by a judge, that error is capable of correction in higher forums.
Like, for example, when I'm talking about the Sai Baba, GN Sai Baba case, Professor, the forensic evidence showed in a particular manner, and there were many who felt that, there were people who were anti-Naxal, who were decision makers, refusing him bail, refusing him the facilities that he wanted. This is just one case. If you don't want to talk about a case in particular, I understand. But like when we were talking about labor issues. So if they already have a preset idea about certain issues, do they hesitate in giving bail? Do they hesitate in or they curb the freedoms of a person. It legitimately should.
That's what good advocacy is all about. And people underestimate the role of advocacy in the court. A case is not concluded until the last word in a case is said. And speaking for myself as a young lawyer, I argued before judges who are on both ends of the spectrum. Tough judges on a particular issue, judges who are not so tough on a particular issue. And we argued before all of them. And we always had this great sense of confidence that if I had an adverse verdict, I could go higher. But the fact of the matter is that, judges do decide on the basis of the record. And that's the element of institutional trust which we must have. Now, the reason I'm not talking about a particular case is because when a particular case is decided by a colleague, I shouldn't be commenting on that.
Right.
Except when it came to me on the judicial side. For instance, if a case was decided by the High Court. And I don't want to take sides on any particular case which has been decided by my court. But having said that, ultimately it's for every judge to take a decision based on the record of that case. And we have to accept the fact that in an institutional system, there will be cases which will go both ways. And the fact that cases do go both ways is part of the process. It's part of a human process which plays out in the courts. That should not be used to target individual judges. And when individual judges are targeted, then you feel that the system is being suborned by people who want particular outcomes. And that is not acceptable. That's just not acceptable.
Okay. Finally, sir, I also want to ask you about now as India goes on to the high table, there are international disputes which are going to happen, Indian businesses which are going to go the wrong way, right way. All this is going to happen. There's going to be interlapping of cases which are going to happen internationally and nationally. How do you see this panning out in the next couple of years?
Well, our judges apply our law, right? So Indian judges, when they decide cases, apply the parameters of the law which is enacted by Parliament and by our state legislatures. We apply international conventions to which India is a party in interstices, as we say, to explain provisions of our law so as to bring them into a manner which is consistent with our international obligations. So, for instance, the Convention on the Elimination of Discrimination Against Women or the Convention on Child Rights. We use these conventions to which India is a party to give better expression to yardsticks and parameters which are contained in our own law. But ultimately, the function of every judge in India is to apply our law. We cannot decide a case on a principle of international law or a principle of law in another country in supersession of our law. But there's again a nuance in that.
Exactly. That's what I was saying.
In arbitration law, for instance, in arbitration law, parties can decide upon the seat of the arbitration and they can decide on the choice of law. So, in that sense, an arbitration dispute, say, between an Indian company and a Venezuelan company or an Indian company and a South African company may yet decide that the venue of the arbitration, the seat of the arbitration would be Singapore, but that the substantive law which will apply would be UK law. And in which case you would apply the law which parties have chosen. But that's in the context of, purely a commercial dispute, such as arbitration.
Reason I also bring this is because of the American system. Like now this whole Adani issue which is happening. And Mr. Kanwal Sibal, he tweeted the other day and he said it's sheer high-handedness, abuse of US power. If the US has information on acts of bribery, they should move the Indian legal system. The indictment is against the Indian national for committing acts on Indian soil. If that is the case, extraterritorial jurisdiction claimed by the US violates the sovereignty of other countries because it's talking about taking action in India against Mr. Adani. So then now this whole thing is going to happen, where judgments are passed on Indian nationals for having given bribes in India, supposedly having given or allegedly having given bribes in India. This overlapping, explain that to a layperson like me?
Look, I wouldn't like to speak about any particular case because
I
though I've
understand.
ceased to be a judge, my discipline of having a record and papers of a case before I has had an opinion has still not gone out of my life.
Okay.
So I shouldn't be speaking something merely on my reading of what has happened in the newspapers or what has happened on the electronic media. So I would not speak on a particular
But you
case.
did speak on the Hindenburg report,
Because
on
that
this.
was a case specifically which came up before the Supreme
Yeah.
Court. But the principle of law which every Indian judge follows is that when we decide cases which come up before us, either on the criminal side, the civil side, the commercial side, the constitutional side, is that we apply provisions of our law. There are exceptions, which I said, when we are mandated to apply a law other than our law. And I gave you that example where in the case of an arbitration dispute between two parties, parties have agreed that the choice of law would not be Indian law, but the choice of law would be, say, UK law. In which case a judge would apply and see whether the standard of that particular law is fulfilled or otherwise.
Okay.
But otherwise, as Indian judges go, we are duty bound to answer cases in terms of the law which governs our jurisdiction.
Okay.
And what governs our jurisdiction is a law which is enacted by our parliament and by our state legislatures.
Right. Finally, I have to ask you that what do you do to chill? Do you watch cricket? Do you go for a walk? Meditation, you said you do. What do you do to chill out? Or is it reading? What is your
Well, I have.
mantra?
I think I have a fairly eclectic taste. I like to listen to music, and in music, I also listen to different genres of music. I love to listen to Indian classical music. I love to listen to Western music. I like to read. I like to do yoga. I take a walk every morning. I love to travel.
Where do you go for a walk in Delhi? Where? It's not possible.
It's all so polluted of late,
Yes,
yes.
yes.
So of late, I've been just walking in, a little corridor, going up and down because you have to have some exercise. And
sport?
Sport, I love cricket.
Okay.
I'm very fond of cricket. So even if it was a very busy day in court, followed by administrative work of 4 or 5 hours in the evening, before wrapping up for the day, I would look at those YouTube highlights on the India-South Africa or India-Australia or India-UK series, as I did last night as well.
Okay.
So
that these things you need, right? In the high stress life that you
Yes,
lead.
of course.
You need to zone out and you need to do this. And how much time does a Chief Justice of the Supreme Court get with his family?
Well, I shouldn't be making any confessions here because that might be held up against me. But very little, honestly, very little.
Okay.
In fact, it's after I demitted office that I realized what I had not had the benefit of doing all these years, with just sort of sitting with family and having a nice lunch or, sitting over dinner without that stress of having to get back to work right after dinner. So you can actually have dinner and then allow a conversation to linger. So
Do you
I've
discuss
missed
your
all that.
judgments with your sons?
Oh, no, not at all. They don't discuss anything I don't discuss what they are doing in their life as lawyers. And they never discussed with me what I've been doing
Why?
as my... there's that element that, I want them to have their sense of autonomy and independence. And they realize that they have views on what I am doing and the issues which are coming up before me, and they wouldn't discuss those issues at all
So
with
these
me
are
because they are
very strict
professional. Very, very
boundaries.
strict boundaries.
Okay.
With my spouse, a little different. I mean, because especially if it was something relating to gender, which is very close to our heart, or the environment, which is close to our heart, or disability, which is very close to both of us. I'd just have a little, maybe throw up an idea at the dining table or something like that. But with my sons, who are professionals, not in the least. They would never speak about anything to deal with.
Would
my
you
own
now like
cases.
to open an X account? Would you like to open an Instagram account? Now that you're out of the judiciary, would you like to do social media now?
Well,
Or
you've
no?
given me an idea. Let me think over it.
Because you're so nerdy. So I would think that you would do. Do you play video games at all?
No, I don't play video
You
games.
don't? Okay, all right. But you would like to do these kind of things, right? Now that you're, if you were to get into the teaching profession, you want to watch movies which people like watching these days, youngsters?
Oh yes,
You do.
absolutely. The few movies which I watch are all on recommendations of others because I never had time to watch a whole lot of movies and then see which are the best ones to watch.
So what kind of movies? Science fiction or?
No, not really science fiction. I like to watch movies which didn't add to the stress of judging, So, but I
Okay.
loved one of the last movies which I watched was Lapata Ladies.
Okay. You
And
like that.
we actually showed Lapata Ladies to
In the court.
all
Yeah.
our staff in the court.
Yeah.
And also 12th Fail.
Yeah, we covered that. Yes.
And 12th Fail as
12th
well.
Fail, okay.
And the actors and the producers came to the Supreme Court to talk to our staff about what making the movie was all about.
But would you read at all? Would you read fiction? Because your work involves so much of reading. Would you read fiction, or would you read autobiographies, biographies? What would you read?
Yeah, I do. I thought I read a lot more in terms of autobiographies, biographies. I do read a little bit of fiction as well, and I hope to read more of fiction now. The latest book, two books which one of fiction and the other one which was non-fiction. I'm reading William Dalrymple, which is again historical.
Historic, yes.
Which is historical. And I'm reading Yuval Noah Harari's Nexus, which is the other book which I'm reading. But I also read a lot of, I've read a lot of Hindi for that matter.
How
So
come?
I'm reading a book of poems by Ramdhari Singh Dinkar right now.
Okay.
So,
That's impressive.
yeah,
And you're reading it as a translation, or you're reading... original?
translating the original in Hindi.
Because you're a
reading
Delhi wala, right?
And
You lived here in the neighborhood, I'm told.
and I also went to Allahabad. So
And Allahabad,
I have an
that's
Allahabad
right.
background as well.
Yes, yes.
So I read a lot of Hindi as well.
Okay.
So
I'm sure
great fan of Munshi
your
Premchand.
Tuta Stephanian crowd is thinking that, oh my God, he's reading
I
regional.
I read a lot of regional literature as well.
So this is
And-
another debunking of what Mr. Chandrachud, Justice Chandrachud is all about. यही तो रोना है मुझे अंग्रेजी नहीं आती और आपको. This is the video of a lawyer and a judge arguing over the use of Hindi. Yeah, you were talking about some of the judges who come from tier 2 towns. They probably don't speak English in the way, say, a Nani Palkewala would talk in English, or a Soli Sorabji would speak in English. That kind of, or even why should I go there? Or Kapil Sibal, or the other lawyers speak in English, and this is the lawyer who says that मैं हिंदी में नहीं बोल सकता इसीलिए, I mean English में नहीं बोल सकता.
But that's the strength of our system, right? It shows that our lawyers and judges are so rooted to reality. I had a colleague in Allahabad, when I was Chief Justice of the Allahabad High Court, who wrote all his orders in Hindi. And I asked him, I said, साहब आप सारे orders हिंदी में लिखवाते हैं? So he says, मैं क्या करूँ, मैं district judiciary से आया और हमारे पास English stenographers ही नहीं थे. तो English लिखने की आदत ही नहीं पड़ी कभी. So he wrote everything in Hindi. But that just shows you the diversity, of the system, of the Indian judicial system. And that's how all of us, I mean, I was, a product of an English medium school. My parents didn't go to an English medium school. My sister and I went to an English medium school. But, I went to an English medium college, university, Delhi University. But yet, when I went to Allahabad, I realized that the lawyer would say, "May it please your lordship," and then start talking in Hindi. And, my ability to speak in Hindi in whichever way I spoke at that time, it reached out to the hearts of people because they realized that you could converse with them in a language which was close to them, in which way they wanted to express their grievances, in which they wanted to narrate the stories of injustice of real people who came to the court. And I think, therefore, it's necessary for us to emphasize regional languages in the work of the judiciary.
Tempers rise a lot in the courts. I mean, now that we are watching it on live, and you are supposed to be this, or one saw you as being this very equanimous kind of a personality, and then suddenly one day you just banged us, I'll throw you out of my court when you got so angry. What happened that day? How did you lose it that day?
Sometimes, I think...
It's my court.
Sometimes your anger gets the better of you and the lawyers get the better of you. You're constantly telling yourself when you go into the court that I'm not going to lose my temper and I'm going to maintain my calm, especially in certain areas where you have multiple lawyers screaming at you from all sides. But sometimes, obviously, you're human. You sort of you miss the boat, so to speak. And
so when you're sitting in a panel and you have disagreement with the other judges, do you snap? Or
no, not at all.
No.
I think, because over a period of time, we were three of us sitting in the Chief Justice's court, for
bench,
instance, or in the High Court's two judges, or sometimes 3. But normally Chief Justice in India in a bench of 3 judges. And when your 2 colleagues give you a different perspective, I always looked upon that as an enriching perspective, because one of your colleagues would tell you something in a case which you had missed. And, listening to that perspective, you would always say, oh, yes, you're right. And, you would always accept that viewpoint. I always had my own formulas. For instance, if it was a case of the grant of bail, I would always feel that if one of my colleagues, even if I was not completely inclined, or I was wondering what to do, if one of my colleagues said, well, let's grant bail here, I would say it's a question of personal liberty. So let's go with the colleague who is granting bail.
Right. Huh.
So, you follow these unwritten ways of conducting yourself. But even when there was a difference of opinion, sometimes where there's a very strong difference of opinion, you'd retire to the chambers, or, when judgment is reserved, you'd go back to chambers and sit with your colleagues. And we'd always, 9 cases out of 10, we'd find a solution.
Okay.
Well, I always told my colleagues that you are entitled and perfectly within your rights in writing a dissenting opinion. Just as I wrote a dissenting opinion. I wrote a dissenting opinion in the Aadhaar case, in the Bhima Koregaon case.
Yeah.
Mine was a dissent. I wrote a partial dissent in the marriage equality case. So I always told my colleagues that please feel completely free to write a dissent. And I have no problem with that. I don't take it to heart.
Okay. And in the Ayodhya case, was there dissent? I mean,
oh no, not at all. We were all unanimous.
But in the discussions that were happening,
everything came down to one. Well, obviously there are different perspectives.
Okay.
When you're assessing the testimony of a witness, a colleague will point out something to you which that colleague thinks is of great importance. In that case, it's all about the oral evidence and the documentary evidence. A colleague will tell you something about the documentary evidence which you have discussed in your judgment. So when the draft is circulated, a colleague will send you a little note with a marginal note saying that on this, please see this particular document exhibit so and so. Would you like to just dwell on it a little more? That's the actual consultation process which takes place between colleagues.
I want to ask you a question. If you don't want to answer it, that's perfectly fine. But I have seen you talking with Prime Minister Modi, and we as journalists used to watch and saying कि okay, 3 minute हो गया है, 6 minute हो गया, अभी भी बात कर रहे हैं, क्या बात कर रहे होंगे? And very animated conversation. You don't give away anything with your expression. He never gives away anything with his expression. Very poker faced, and you have this conversation going. You've met with chief ministers, prime ministers and all. How have your interactions...
And presidents as well.
And presidents. How's your interaction been with him as a person-to-person level?
Or with all of them, you mean?
Yeah.
The interaction is, I feel it's extraordinarily enriching because I respect the political spectrum. Because I'm not one to, sort of belittle political spectrum, even if they are critical of the work which we do. Because I feel that democracy is sustained by institutions at different levels. By civil society, very important ingredient of democracy. By the legislature, by the executive, and by the judiciary. And talking to, different ends of the political spectrum, for instance, President Pranab Mukherjee had a wonderful convention which he developed of calling individual judges of the Supreme Court and their spouses to come and meet him. And it was amazing because the Honorable President would have done his complete research on the work of that judge, your hobbies, your interests, what you have written on. And he would have this...
Knowing Pranabji, he would have done on your parents also.
He would have a free-flowing dialogue. And he would ask you, why didn't you ask something about me, about my background that you would find interesting? So I asked him about his time as a junior minister in the government, as a senior cabinet minister, the work which he did in different ministries, and not in terms of the decisions which he took, but the processes of reasoning, and so on and so forth, the books which he read. And it was enormously enriching. Likewise, I spoke at length with President Ramnath Kovind.
Okay.
And I learned so much about life from his own personal history in terms of the work which he did even before he became the President of India. I have had the good fortune to engage with President Draupadi Murmu. And, one thing which comes through my interactions with the Honorable President is a sense of compassion And, the desire that justice should reach out to the most marginalized of groups. The President is so aware of social reality. When she spoke, for instance, in the Supreme Court Constitution Day celebrations, she said, well, why are we crowding our jails with petty offenders? She is aware of social reality, which affects our under trials. And that came through when, we had these deliberations, not on any particular case, not at all, but just about an understanding of their backgrounds, their social life, the way they look upon Indian society, their vision for the good society. And in that whole process, you are really enriched as a human being.
And Prime Minister Modi?
And likewise, about when, obviously, say, take for instance a case where I've had a selection committee meeting for selecting, say, the director of the Central Bureau of Investigation with the Prime Minister, the leader of the opposition, and the Chief Justice of India. You'd be surprised at the maturity at which discussions take place after the formal part of the meeting is completed. The kind of discussions which take place are core discussions on the future good of our society.
Okay.
There is no element of politics. You have the leader of the executive, the Prime Minister, you have the leader of the opposition, and you have the head of the Indian judiciary. And there's a discussion on what's happening maybe in a different part of the world, maybe sometimes in our neighborhood.
Would he ask for your opinion on it and have a genuine discussion with you on, say, something of international importance, say, sub G20 maybe?
I read a lot apart from the law. Economics is something which was very close to my heart. History is very close to my heart. And I wouldn't stop short of giving my opinions if there was a conversation on any of these related subjects. One thing which I found about the Prime Minister is that he's an extremely involved and careful listener. When someone speaks, even when the leader of the opposition would speak over a cup of tea, he would be focused completely on what was being spoken. Likewise, if I was, giving my opinion, even on the subject for which we were meeting, he would keep everything down and listen very, very closely.
Okay.
And that's something which I found about the Prime Minister in the course of our official meetings. And that's something which I feel is mutually enriching. As I said, we never spoke about any case which we were to decide. I'm sure he had his views about what we decided, because not all that we decided would necessarily favor the government. It would go the other way as well. But never once
Electoral bonds is something that has
never once did he speak about that. I mean, it was a different jurisdiction altogether.
All right. Okay. On that note, thank you, sir, for spending so much time with us.
Thank
and we
you.
look forward to seeing how your career path moves from here.
Thank you so much.
Thank you.
Thank you.
Thank you very much. Thank you for watching or listening to this edition of the ANI podcast with Smita Prakash. Do like or subscribe on whichever channel you have seen this or heard this. Namaste. Jai Hind. Click here to watch the previous episodes.